Добрий день. Good afternoon. Today we are conducting the interview with Mr. Stanislav Grishin, the candidate for the position of the head of the disciplinary inspector service. So the interview will be conducted by the selection commission, which is today its entire composition. I am Reda Molene, the chair of the commission, and also members of the commission are present: Yulia Bokova, Olena Kovby, Olha Popikova, John Ehrlich, and Pavel Zelenchik. As it is not your first time in the interview with this commission, you probably know the procedure, but I will remind you shortly that the interview will last for about 60 minutes because it's the interview for one position. Of course, it can be extended for 10 minutes or so if there is a need. And you will be asked some questions about your professional competence and skills, including some managerial competences, because it's the managerial position, and also concerning the integrity. And of course, due to our time limit, you are kindly asked to respond as concise as possible. And also, I would like to inform you that the interview is broadcasted, and if you have any information which falls under restrictions for its public disclosure under martial law, please inform accordingly during the interview. Would you have any requests regarding the composition of the commission or other requests?
Thank you. Dear Chair of the Commission, I have no requests before the start of the interview.
So we will start from your presentation of your understanding of the mission of this service and of course your vision. You will have up to 10 minutes for this, and in the end of the interview, after the questioning session, you will have several minutes to comment. So the floor is yours for your introductory speech and your presentation.
Thank you, dear Commission, and I would like to start, first of all, from the words of gratitude. Gratitude for the credit of trust that you expressed to me during the previous competition. Thanks to your decision, I have the honor to be a representative of a new legal profession, which did not exist before. And today I would like to talk to you about the future. During the previous interview, there were many questions about professional experience, about the competence. So first of all, I would like to start as to how I imagine the service of disciplinary inspectors. I've been thinking for a long period of time what it reminded me of, and the most specific metaphor, the most specific association is the grass that is breaking through the asphalt through this very thick substance. And here I see many senses. First of all, we are creating something new. We are not destroying the current system. We are trying to create something new, something beautiful, something that is growing so rapidly. That is the first aspect. And the second aspect is that we have to understand, and we already work in extremely difficult situations. Here we have the context of the full-scale invasion, of the global collapse of the judiciary, and of course we need to take that into account. So I would like to ask you to imagine the society in which we have justice as the superior value and where we have trust of citizens in the judiciary. I'm forming the vision of the SDI as follows. The SDI is an independent, transparent, highly effective structural unit of a new generation in the sphere of disciplinary proceedings with respect to judges, which ensures justice and trust in the judiciary. And here I at once can talk about several elements of our vision. Our task is about justice and trust in the judiciary. I disagree that our task is about the number of proceedings or about the number of judges brought to responsibility, because our goal is more global and more strategic, and we have to aim to achieve it. And the other elements of this vision are about the nature of our work, that is, independence and objectivity. I will tell you in more detail about that through principles. That any external observer should have no doubts about independence and objectivity of the disciplinary inspector and the service in general. And transparency, openness, all of our decisions and motives for decision making have to be accessible and available for the public. We have to be very open. We have to be open not with respect to fulfillment of any law or regulation, but it should be also our internal vision of how this service should be working. We need to have high effectiveness. I'm against people coming to work and being at work. Our work has to be effective and have to be measured through specific metrics, which I will mention as well. And our service is a new generation. What does it mean, a new generation, as a part of our common vision? So yes, some elements are the same, that is about transparency and accountability. We have to use the most modern methods in our work, that is about digitalization, about innovative processes, that is about maximum automation of process in order to remove the human factor where it can hinder performance of some tasks. We are oriented at some specific achievable metrics and indicators. We support in our work independence, ethics, and independence. We are not. We do not live behind the glass. We effectively communicate with those key stakeholders which are a part of the justice system, that is the civil society and independent associations and self-governance judiciary bodies, etc. Ongoing self-improvement and training. It has to be, it's a must-have. It's our duty. I love studying myself, and I will tell you about that as well. I'm not talking about hard skills education. I'm also about talking training in a very broad sense, to involve, for example, public opinion leaders, to improve our skills as a team all the time. And I suggest, and that is a part of the vision, a new design of the disciplinary proceeding. It has to be simplified as much as possible so that it is clear and comprehensible for all parties of the process. That is the slide that is a provocation, very risky slide. I'm deeply convinced that the service of the disciplinary inspectors and its head have to be active subjects of advocacy. We should not only create within current procedures, we need to work on improvement of these procedures. In this context, the head should be quite proactive. There have been many discussions and during interviews and during other settings about the need to unify grounds for disciplinary responsibility of judges. They have to be clear and comprehensible. I'm talking not about
For this interruption, please proceed. Everything is okay with translation? Yeah, thank you. Please proceed.
I'm talking about the unification of grounds for disciplinary responsibility, and I'm talking not only about amendments to Article 106, 107 of the law on the judiciary, but I'm saying that the SDI has to be actively working on formation of so-called guidelines, policies, so that judges as a party to the disciplinary proceeding, and complainants would understand the perspectives of some proceeding, whether there is a violation of a specific procedural law, whether it entails disciplinary responsibility or not. I had experience of being a complainant under the disciplinary proceeding, and this is a gap which I personally lacked in order to submit disciplinary complaints in a quality manner. Secondly, I'm talking about expansion of methods and tools for investigation of disciplinary complaints. Since the moment of adoption of the previous competition and until nowadays, I've watched many broadcasts on the work of disciplinary chambers, and basically the only tool that exists nowadays is sending requests and receiving answers and responses. But almost in every of these proceedings, I had thoughts emerging that these methods and tools should be expanded and can be expanded. In some cases, I'm even talking about inspection field meetings of the disciplinary inspector, trips of the inspector, to be able to question not only the judge but other participants like the secretary of the court hearing, assistant, of course, if that's relevant. I'm talking about the fact that the disciplinary inspector had opportunity to get opinions of experts, specialists, if necessary. A new design of disciplinary complaints, it has to be made as clear and comprehensible as possible, and our priority will be electronic disciplinary proceeding. I believe that in this context we should be going ahead of the time with respect to testing of the SITS, the unified system. I know that the HCJ has been working actively on launching this system, and I think the disciplinary service has to take active part in that. There is controversial issues about submission of a fee for submission of complaints. I think it should be. Existence of 10,000 complaints is not correct. This fee, of course, should be minimum, and it has there should be a broad category of citizens exempt from paying this fee, but this fee should exist. And I believe that it is also necessary to introduce the instrument of written disciplinary proceedings. I think that most disciplinary proceedings are heard with the absence of the judge, with the absence of the complainant, and the rapporteur is just reporting on the materials, and then the decision is made. And I'm convinced that such decisions could be taken within the framework of written disciplinary proceedings, and it would save time and resources. I've mentioned about the development of indicators. I'm a man from the private sector. Business cannot exist without performance indicators, and I'm convinced that any public law institution or body should use indicators as well. And my suggestion regarding indicators is as follows. First of all, we should be aimed at ensuring optimization of the period of consideration of complaints. There should not exist a situation when there are dozens of complaints accumulated with respect to the judge and they are not considered for years. We should measure the period of time since the moment of receipt of complaint and the final decision is made. Secondly, we should actively delve into communication. We should measure the level of satisfaction. Yes, it can sound a bit strange, but at the same time I'm convinced that at the end of any disciplinary proceeding we should communicate with the parties so they could provide their feedback with respect to the work of the SDI, what works well, what works not that well in their opinion, what should be strengthened. I'm also talking about the work with our stakeholders and with the representatives of the civil society, with leading civil society organizations in this field, with self-governance judiciary bodies, and we should also communicate with them about their expectations, what they expect from our work. And similarly, I'm deeply convinced that it is necessary to communicate with business associations, with the American Trade Chamber, with business ombudsman, so that white big business is informed about the work of the SDI, so that they could provide their expectations regarding our work. The specific indicator is transparency and reporting. I am deeply convinced that everything that we produce, all the decisions should be publicly available. I'm talking about our opinions, we should publish them as well. I'm also deeply convinced that we should publish decisions of disciplinary chambers. Once the opinion is returned for improvement to the inspector, so that the society would see based on which grounds the disciplinary chamber disagrees with the work of inspectors. Similarly, we should process this feedback that we are collecting, and if we have that in the format of recommendations, then we should report on implementation of these recommendations, so that this is the service that is continuously improving. It is also necessary to measure the correlation with respect to the open proceedings for each inspector, to take into account their efficiency coefficients, and to work actively in this sphere as well. With respect to those tools in disciplinary proceedings that I'm suggesting to introduce, that is expansion of toolkits, that is how inspectors can investigate the specific proceedings like field trips, questioning of the parties, opinions of experts, etc. I'm convinced that in the most complicated disciplinary proceedings with many instances, it is appropriate to appoint a group of inspectors, similarly to how it works in criminal proceedings, where each inspector will be responsible for each sector of work, because there may be some proceedings relating to several proceedings, and with respect to each of the instances it's necessary to provide a part of the opinion. I'm also deeply convinced that it is appropriate to introduce some specializations of inspectors. There should exist the general specialization to which all inspectors belong. With respect to specialization, my suggestion is to have it with respect to specific types of judicial proceedings, like administrative, commercial, criminal, etc. We need to have innovative approaches to training. We should make it as open as possible. We should also invite the CJ members there. Separately, I would like to mention that we should build the new corporate culture where each employee of our service has to feel comfortable at work, and they should feel safe as much as it is possible, taking into account our work and the martial law. Similarly, in my opinion, that is the key function of the head, is to build adequate quality horizontal connections inside the service, so that disciplinary inspectors could share the best practices among themselves. If, for example, the inspector has found some innovative approach, so that it would not be like purely his or her solution, but a joint tool that would improve the work of the entire service. And the after-action review, that is the notion without which I can't live. I've taken it from the military service. Here I'm basically talking about the NATO standard, that any operation that is being implemented has to be thoroughly reviewed, whether we have achieved the goals that we have intended to achieve, what went wrong during the operation, and what should be done in order to prevent these mistakes in the future. By the way, this principle is very similar to cognitive therapy as well. If the person has depression or a panic episode, you come back to cold reason and you rationalize everything. Of course, not in every disciplinary proceeding, but in the most complicated ones, or where we've made some gross mistakes, we have to analyze our own conduct in order to prevent these mistakes in the future. The first steps. The service is launched. What we are working with, what we should do. These are not the steps stage by stage. I think that most of them have to be launched in parallel. The zero step, even before the start of the work. That is the audit of the current system of disciplinary proceedings as to how the system is working now, to understand it completely, to spend a lot of time. I think that should be done after the decision of the HCJ on appointment to the position, and before you start implementing these duties at once. It is necessary to conduct a complete audit of this system. The team of the inspectors, together with the head, have to conduct strategic planning sessions in the most democratic form. They have to choose and adopt our common vision and principles, which should be later on stated in the regulation on the work of the SDI. At once, we should start thinking about how to overcome this organizational chaos, and this is also the function of the head of the service. That is discussion about premises, about water supply, energy supply, alternative energy sources, because I understand that the winter is coming and it is a very up-to-date topical issue, so that we could continue working without any interruptions.
Мова йде про те, що ми повинні знайомитися.
So the same, we shall familiarize ourselves with the composition and of different structural units of the HCJ. We shall listen to their expectations regarding the work and operations of the Service of Discipline Inspectors, and of course to start working as soon as possible, because the practical experience which we are going to gain, it will become a practical foundation for our further activities. My proposals for this session of strategic planning regarding the principles that the human-centered approach, integrity, efficiency, and transparency. Those four principles have both external and internal element. Human-oriented approach, that's as an internal element of our work, that each person as the Service of Discipline Inspectors is a valuable person. We listen to their opinions, and external component also, that we respect and maintain rules, rights of each party to the disciplinary proceedings, both of the complainants and of all other parties. So transparency is also about metrics and other things. Some opinion regarding our model of functioning, that we need to work all the time. I think that the function of the head of the Service of Discipline Inspectors should be also to have quarterly one-to-one meeting with each employee of the service. I have this experience just recently. Last week, within our Miltech company, I had such meetings with 65 employees, and those meetings took place for 2.5 days. I know how it should be done. I know the models. I know how to do it in such a way to listen to opinion, reflections of each of them. We shall report on the permanent basis to the public on our work, and it's not only about statistics, but also about our conclusions regarding our work and what we implement in practice. We shall also introduce discussion sessions, internal discussion sessions within our service regarding the review of disciplinary processes, regarding the consideration of the constant feedback which we gain, and the permanent trainings for employees, for inspectors, both on hard skills and soft skills. KPIs, which I mentioned before. One of the key problems when such KPIs become very conservative, extra harsh, and they are not helping anymore. So the KPI category is a very flexible category which shall help us to adapt to the reality. And also external communication. We shall constantly communicate with our civic organizations, our public, representatives of the judiciary system, and so on. Thank you so much for your attention. That's the last slide, and here maybe I have some kind of metaphor, and because thanks to the Commission we have 25 disciplinary inspectors, and the role of the head of the service is to make a cool team full of synergy from those 25 inspectors, where each of inspectors is valuable and all of them work towards achievement of joint goals, joint objectives. And that's the role, that's the task of the head to do it. Thank you for your attention.
For your extensive presentation and very detailed description of methods and organizational instruments that you see as the start for this service. And you mentioned also some aspects which are related to team building and corporate culture, organizational culture, which is the essence of the organization, because without people, without their good performance, we cannot have a good organization. So with regard to this, I would like to ask you a follow-up question about your leadership style. You mentioned already human-centric approach and constant feedback, all those aspects. But could you please describe as a leader from your previous experience as well? What is your prevailing leadership style, and what are the main features of this, and maybe some examples of this leadership? And as we have a requirement for the head of the disciplinary inspector service to have good knowledge of foreign language, and your foreign language is English, I would like to ask you to respond to this particular question in English, please. Thank you.
Thank you so much. I estimate my style of leadership as the most democratic as it could be. I don't like the strict methods, so I will try to contact everyone and try to hear everyone in my work. Especially as far as I mentioned that I really studied a lot, especially last time. Now I'm attending the course, it's called the Anthropological Management and Leadership, that is provided by the executives of Kyivstar and other big companies. So it's like the mini MBA for executives. And I'm really pretty much confident about such democratic ways, because they are the only effective ones, especially when we are speaking about the individuals that the inspectors actually are. I worked in very different teams. This kind of teams, they may differ from 10 people to up to 100 ones. As a leader, you must combine different types. For some people, you have to, to challenge them. For others, you have to be in much delicate way not to harm them. So, something like that. Thank you.
So, you are preferring this adjustable or agile leadership, which is responding to particular situations and particular demands of different individuals that are working in a team, as I understand.
I can add that I try to see the team as a combination of stars, actually, and my work is to make them shine as bright as they can be, to see the best parts in them, actually.
To empower them.
Yep.
Thank you very much. And now I would like to give a floor to, is the interpretation working? No? Sorry, just a moment. We should fix this.
Скажіть щось англійською, чи почують наші колеги?
1, 2, 3, can you hear interpretation right now? Yes.
So, the member Olena Kovby will start the session of questions. Please, the floor is yours.
Greetings, dear Stanislav. Here, I will have first question. During all your presentation, you mentioned we. As you said that we need to publish decisions of disciplinary chambers. Who are we? Sorry. Sorry, it was maybe some kind of typo in my speech. So I meant publication of findings of those decisions generated by the service of discipline inspector. So what do you mean under we? The service of discipline inspectors? No, I meant that the service of discipline inspectors is a structural unit of the High Council of Justice. So we cannot exist beyond the system of the HCJ. So when I say we, here we cannot exist beyond the system. So you think that the service of discipline inspectors should publish conclusions of discipline chambers? Not exactly. No, I meant another thing, that we are, as a service, should ensure that such conclusions to be published. So, it means that we are the structural unit of the High Council of Justice, so I don't think here any misconclusion. So you think that you are the structural unit which should publish the decisions? As of now, of course not. As of now, not. But when the service gains its mandate, then yes. Okay, thank you. Another short question. What did you mean when you say that you are a representative of the new profession? I think that the service of disciplinary inspectors and a disciplinary inspector, specifically in understanding of those amendments to the law on the HCJ, so before and as of now, there is no such legal profession with such specific functionality. That's why I think that here we are speaking about a new profession de facto. So do I understand correctly that without the final decision of the HSJ, you think that you are already a disciplinary inspector? No, 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 of course not. No, no. I gain authorities only when the decision is made. But given that Reda has already asked you about your vision as the head, but I would like to ask you about your experience as the head. So please tell about your experience, but please be concise. And how many persons were under your subordination? Thank you. Thank you for this question. I have different experience, both as a leader, as a head, and as a rank and file employee. When I worked in the law firm, I had around up to 10 persons under my subordination. Sometimes I worked as a team lead. When I was a military person, there were from 20 to 30 persons under my subordination. And for now, I consider myself as one of the co-founders of Miltech company, and it's more than 100 persons, and I supervise them. What position did you have at the army? Yes, same. I could go into details. No, no, no. So we have created the situation center, which worked at the Zaporizhia Access. It was it consisted of so many different people. But it was not in the armed force of Ukraine. No, no, no. It was my real function during. So after I was conscripted. So during the operation itself, but. You said that while you fulfilled the functions of a lawyer, so to say, under your subordination there were different people. Who were they? It was a very different composition of a team, lawyers, assistants, advocates, assistants, so on. Dear colleagues, that's all from my side. I have a question. I have a question specifically. Yes. When I was listening to your replies and when I analyzed your documents, your huge experience as a lawyer related to high-profile cases, and you're so proud of them. So tell me, please, what is your goal? What is your aim to be involved into the service of disciplinary inspectors? Thank you so much for your question. Actually, I understand that it's we are speaking here about some victimizing process. I understand that it will not be an easy path. It will be work under huge pressure in difficult conditions and so on. I mentioned it during the previous competition, but to my personal opinion, a disciplinary proceedings is not that much effective as it should be in democratic society. That's why I think that my competences, my skills that I have, could contribute to build a new system within the process of disciplinary proceedings. I'm speaking about the service of disciplinary inspectors as an integral element of the system. So you are ready to put aside the advocates' activities and business that maybe brings even higher incomes than it would be on this position as a service. Yes, yes, I'm ready. And also I would like to mention that during my military service, I suspended my advocates' activities. And for now it's not suspended. Now I have renewed, but and also I would like to mention it and underline it. After the Moscow invasion, after being dismissed, even on mental level, for me, it's quite difficult to handle different advocate services. So mainly, at a meal tech company, my work is related to the production of FPV drones. And why? Why did you say that for you it's difficult to provide advocate services and lawyer services? Because one of the aspects of my work of the law firm which I'm so fond of, I loving it, that you are as an opponent to the state. And for me now, during the war conditions, it's difficult for me to be the opponent to the state, you know. For me, it's not comfortable. That's why you decided to change your area of operations of work. You know, I think that it's some kind of my calling, that I'm ready and I can do it regarding the service of disciplinary inspectors. It's already the decision is made. I already made a decision to become a disciplinary inspector. Okay, thank you so much. Dear colleagues, if I may, I would like to ask a question. Greetings, Stanislav Volodymyrych. I have a short question to you. In your motivation letter, you highlight that critical stations could require unpopular and non-standard decisions. And of course, as a leader, you should be confident to make the decisions. Yeah, I fully agree with you. My question to you, regarding your previous experience, do you have any such experience of making unpopular, non-standard decisions? And if you have, please be concise when share it. Such decisions are made on the permanent basis without any interruptions. Whatever you do, either you are engaged in the army, in the military person, or when I provide attorney services, or when I work at the meal tech company. Maybe the last thing, which was quite complicated, we have discussed it a lot. As a meal tech company, we work directly with military units. We have direct communication with the military teams and drone pilots and so on. So the mechanism of public procurement, which is carried out by the Ministry of Defense, is not an effective one, unfortunately. My huge regret. There are many different aspects which are absolutely non-public, but I would formulate it that they decrease general development of the sector, and it's so important. And actually, the public procurement part, the public procurement agreements impact on the number of employees, on what is procured, on so many different things which are interconnected. So when we faced again this wall of non-transparency and misunderstanding of some procedures, we made a decision to actually to exit, to go out from the public communications, to comment what is possible regarding the public procurement from the side of the state on the UAV drones. This communication was effective. Many public activists criticized us for that communication, for that comment that we made, but as a result of such communication, even now we can say that the procedure is being changed as a response to the position of the producer of those drones. It was one of the examples of difficult, non-standard, unpopular decisions, and we decided because before, no single producer made such made such communications. In business, you always need to make such difficult decisions. Even a decision to hire a person is a difficult decision. I have this experience to hire and fire people based on different circumstances. It's always not easy. Thank you.
One short question, and we'll give the floor to my colleagues. Again, about this managerial aspect of the work of the head of the service in building the whole work. You mentioned that for the effectiveness of the work, it's very important to monitor, and for this we have to have clear KPIs. That's of course the usual practice now. So but usually there is no problem with having kind of quantitative criteria or indicators how to measure. But sometimes we have problems or issues having qualitative, how to measure quality of what we are doing. So could you explain how you see how the work of disciplinary inspectors could be measured in qualitative indicators? 1, 2, or 3 kind of these indicators, how to measure. Sorry, no translation, sorry. Just a moment. Okay. You can proceed because our colleagues, you have interpretation, right?
Yes.
Okay, so you can proceed. Thank you very much.
Дякую за питання, воно складне. Я думаю,
Thank you so much for your question. It's a difficult one. I don't think that there could be any final answer to your question, because I think that it's extremely difficult to apply KPIs for the public organizations. For business, it's a little bit easier because in this context, because we have some objective indicators which could be measured. Regarding the public sector, it's much more complicated. That's why we are speaking that it doesn't matter what specific indicator is applied. There are always pros and cons. Those arguments for applying or non-applying of this or that indicator, I'm fully sure that we need to measure the level of awareness, how the service works among different professional organizations. What do you know about the service, how it works, what are the novelties at their work? That's kind of outreach part of our work. Also, we need to measure the level of satisfaction regarding the procedures. Do you think that those procedures are necessary, fair, relevant? Another objective indicator is timing. Timing of consideration of a disciplinary complaint, how much time this complaint was under work of this specific inspector. Also, I'm going to pay significant attention to those cases when disciplinary chambers return back to the service some complaints, with which conclusions, what are the reasons, what shall we do in order to mitigate such cases as much as possible. Also, we need to pay attention to the level of the cancellation of such decisions when such decisions are reviewed by the HCJ, I mean by the plenary part of the HCJ, by the chamber and so on. Thank you.
Good afternoon. You had mentioned the issue of transparency for the service, and procedurally the inspectors will be conducting investigations, and then they will be writing opinions, and then they will be presenting those opinions before the disciplinary chamber of HCJ, which will be a public process. Short of presenting the opinions to HCJ and defending those opinions, what role do you see transparency playing with the work of the disciplinary inspectors and the work of the service?
тут декілька.
Here I have several aspects that I would like to mention about this. It should be pointed out that even nowadays the HCJ publishes rulings on opening of disciplinary proceedings where it quotes some aspects. So right now the member of the HCJ is the rapporteur, makes specific conclusions, and in rulings on opening proceedings there are references to the work conducted by the rapporteur while performing this task of the inspector. So I believe that there will be no harm or negative consequences from publication of opinions of inspectors. On the contrary, it will ensure that transparency and openness. And the key is that the society can understand motivation, why the disciplinary inspector has reached a specific conclusion in this case. Similarly, possibly a controversial issue about the moment when these opinions should be published. But at the same time, my personal position is that it should be published once the inspector has sent it to the respective disciplinary proceeding. Then, of course, taking into account personal data, so depersonified, so that it would not be generally available. But I think that that is the key answer to the question. And that is a duty, that is a must in our work. And it will also discipline inspectors as well, because the inspector will know that this opinion will be available not only to the HCJ, but that it will be open and it will motivate and encourage people to prepare quality documents.
Thank you.
Good afternoon. My first set of questions will follow up to the question of my colleague about the leadership style of yours. And you said that it would be the most democratic as it can be. Can you mention some of the downsides or challenges the most democratic leadership can face when executing this new office?
Дякую за питання. От якраз
Thank you for your question. In the course Anthropological Leadership and Management, we talked about the dark side of leadership. That is the topic that is rarely raised in business schools, but it is incredibly important. And for me personally, it is very important, because a leader is a lonely person. A leader is the person who is anxious all the time. Just because all of these challenges that the leader faces can rarely be understood by anyone else. I think that we do not have that many people in Ukraine who face such challenges that the head of the SDI will face. And in this context, authoritarian leadership models, some harsh models, in the long term will only worsen the situation. They will undermine trust inside the team. I'm not saying that democracy is the absolute notion. In some meaning, this is a very relative category. But I'm talking about being as human-centered as possible in the team of the SDI.
I was listening carefully, and I heard several downsides or challenges of the authoritarian leadership style, but I didn't notice any downside or challenge of the most democratic style.
Окей, я думаю, що
Okay, I think that again, we are talking about possibilities and probabilities to some extent. The democratic management style is longer. It takes more time. It's more strategic with respect to authoritarian leadership style. And in the short term, it may seem that the democratic management model is not effective because it is necessary to have the result here and now. We have a lot of works, and that's it. But I'm deeply convinced that we have to create the atmosphere in which the team will feel comfortable to be, will feel comfortable to work. And with respect to this question, I'm recollecting training held by James Comey, former FBI director. That's a training course, Ethical Leadership. And there was a topic on corporate culture, and he was providing examples that from 0 to 3. 0 is the corporate culture like in the army or in a penitentiary system or in prison, where you have a harsh, severe hierarchical model where the manager like when the subordinate person has no rights, so that is the absolutely totalitarian model. And I had experience of working inside such model, in particular while being on the military service, because basically no other style can work there. That's the setting. One is a corporate culture that is transactional. Most public bodies and institutions work with the level of corporate culture at the level of 1, where you address some person, the person provides a suggestion or response. We can even know about birthdays of our colleagues, but we are not very close. 2 in this system means a very warm, comfortable atmosphere, and 3 is almost similar to family ties. And James Comey, who was the FBI director, said that in his opinion, when he was director of the FBI, he tried to build a system where he would have 2.5 as the level of corporate culture between the family and warm, and that is FBI of the US with thousands of employees. Yes, it was not like that, but it was his intention. And I felt very close to this position. And I'm convinced that in the service of disciplinary inspectors, it is possible to build such a system where after days off, people will run to work. They will love to go back to work. They will try to get to work as quickly as possible in order to share their experience, convictions, beliefs with colleagues. And in this system, it is really comfortable to work. And I had experience of working in warm teams, and later on, I always remember them fondly. And I remember these relations fondly, and I still maintain connections with these colleagues years after we finished working together.
My last question in this set is, I noticed that the most democratic or more democratic models may be perceived or may be less effective. Processes can take longer, and your approach to overcome these is to creating the atmosphere where people would be thrilled to do their work effectively. How would you do that?
Гарне питання.
That's a very good question. Some of these models have been mentioned by me in the presentation. These are sessions of strategic planning where each disciplinary inspector, each team member has the right to say something and to be heard. That is joint decision making, including by means of forming some initiative working group that will take part in the formation of the regulation on the SDI. I've also mentioned about one-to-one sessions as a procedure. That's not merely communication with colleagues. It has a specific agenda, what you want to hear from the colleagues. Even a simple question, what I as the head can do so that you could work better, more effectively, and so that our team could work better and more effectively. It can be a very effective question. Like during reflections, just last week I had some meetings in our Miltech company, including the representatives of veterans, people with severe injuries, and they provide very quality feedback, which we can start using at once in order to improve the work of the team and organization.
Thank you.
In the second part, if I may I continue? Time-wise? Yes? Yes? Or
Just inform that we will extend our interview for some time, for 10 minutes or so, because of some technical
Yes.
interruptions, etc. And now we will start this second session on integrity, okay?
Olena is maybe? Okay, Olena and then me.
Let's move on to our next block of questions. During the interview and the previous and this interview, you mentioned your military service a lot. And given that I'm the officer in retirement and I have relation to the armed forces of Ukraine, had at least until last year, I know about the service from the inside during the martial law, during the full-scale invasion, during this war. So I think I have a moral right to ask these questions to you. Can you please tell us, was there the disciplinary proceeding initiated with respect to you during your military services? Thank you for your question. It's very important to take into account the context here of this situation. I would like to emphasize that in general, in life, I never thought that I would somehow be related to the army. I did not serve. I had no previous military experience. I did not serve as a conscripted person because I was released due to my health condition. Mr. Stanislav, I'm sorry, we are limited in time, so let's be brief. Okay, we know about your biography. Clearly answering to these questions. And for me it was a challenge, and a true challenge to be mobilized, even though some performance of duties happened even before the moment when I was mobilized. I served for 22 months, and I was released from military service due to family circumstances. Since 2024, and my condition was worsening. I mean, psycho-emotional condition and chronic fatigue and the processes like that. Plus, the health condition of my father was worsening as well, who also had chronic diseases, and he had hospitalizations all the time to the hospitals, etc. So I was aware and I understood that there would emerge a need for me to resign from the military service. And in parallel, and back then and until now, I have even suggestions regarding military services in other locations. I've realized my right. Upon my own initiative, I submitted a report on being transferred to another military unit, which was directly responsible for combat activities. I'm talking about Battalion 412 of UAVs, which back then was in the General Staff. Now it's a separate type of the Army. And the procedures of transfer inside the Army are very complicated, very non-transparent, are very unclear, especially with respect to the service member. And once I filed the report on being transferred, I was on vacation because there was a need to take care of my father, whose health condition was worsening all the time. And while being on vacation, I returned to the military service and I submitted a report on resignation. And I was extremely shocked. That was a horrible and unclear situation for me, that the military unit did not accept my documents. I was not aware why it was happening. So there were some unclear talks, pressure, etc. The first report was returned due to some absolutely formal grounds, a failure to fulfill with some instructions, who knows which instructions, and I as the lawyer was shocked, because it's one matter to defend your clients who are in difficult situations, but it's another aspect when with respect to you there are some unclear and unlawful actions committed. I submitted the second report, but that report was not accepted. So the first one at least was marked somehow. The second was not marked at all. And since I did not receive anything, no responses at all, I decided that the only way how I could, as a human being, to defend my rights is to file a claim with the court with respect to these two reports and with respect to these two situations. The administrative court took a decision with which it recognized the inaction of the military unit as unlawful. I was, upon the order of the head of the General Staff, I was transferred to Battalion 412, so I continued my service there, and in a quality new military unit, there I exercised my right. I filed my report and absolutely normal attitude towards service members in this unit, and there was a respective decision adopted. I'm sorry, Stanislav. What was my question? Your question was about my military service. No. My question was whether was any disciplinary action with respect to you during your military service. Look, I do not know about this for sure, because I did not receive requests either orally or in writing, so that I would be requested to provide any explanations for some official investigations. Okay, I understand. Can you please tell me what is AOL? That is a criminal offense. That is a severe crime in the sphere of military service. What is it about? There are different approaches to the disposition. I understand the context of your question. I was not absent without leave from my military unit. So after vacation, you returned to your military unit, and all that period of time you were in the military unit until you were transferred to another military unit. Yes, yes, I was not dismissed. I was performing my duties and my personal attitude, and that's a horrible and traumatizing event. I considered it as a sort of repayment for me challenging this denial to accept my reports. And that was the response of the military unit. I'm emphasizing that no one was summoning me for provision of any explanations or investigation. Why did you go to the court? When? I do not remember the month. June of 2024. June. Okay. So you were supposed to come back from vacation when? On which date? Again, I would like to repeat. Okay, according to the materials that the Commission has, on June 17, 18, you were not in the location of your military unit. I can comment on that as follows. I was not absent from the military unit without official leave. I was okay on June 17, 18. Were you on the military unit? Yes, yes, I was there. And I'm not talking about the military garrison. This is a separately things. We're talking about the military unit. Yes, I understand. Were you in your military unit? Yes. I'm emphasizing that those investigations that were conducted were artificial, illegal, deprived of any possibility to achieve the result. Did you challenge the results of the official investigation? Since I did not receive it, then accordingly, I did not challenge it. I was challenging those actions, those unlawful actions or inaction that was committed with respect to me. The decision of the administrative court are available. I've provided them to the commission, and there you can see everything. And I'm convinced that the correctly assessed the facts and specified what was violated by the military unit with respect to their unlawful conduct. And that is a very deep and serious question, because I was mobilized voluntarily. Okay, thank you. Many people mobilized voluntarily. Yes. Yes, that's why we have the possibility to have this interview. Okay, thank you. My next question is about grounds for resignation from the military service. So I suggest to you and to the colleagues, I suggest to you not to broadcast this part of the interview and the explanations of the candidate, of course, unless the candidate disagrees. No, I don't mind. With respect to broadcast or a suspension of the broadcast? Since you initiate to close this part, of course I don't mind it. Okay, then I suggest not to broadcast this next block of questions that I have. Are you okay with this, colleagues? Okay, please suspend the broadcast.
Podcast after consideration of the questions which are related to the sensitive data of the third persons. And now we will proceed, and we will have to extend our interview for again maybe 10 minutes just to give you an opportunity to respond to all the questions and to give your position if everybody agrees with this. And Mr. Stanislav, would you agree to? Okay, thank you very much.
Пане
Just Stanislav, when you filled in the documents after you were conscripted or mobilized, you indicated some information on your close persons, and you indicated that you have only a father and a mother. Give them for me to familiarize myself with them. Maybe I can comment upon them. I tell you that you indicated only your father and your mother, and that you don't know whether your mother is. Why didn't you mention your brother? I can tell that, as to my opinion, and as I thought that I needed to mention only my parents, only those close relatives, which I'm required to take care after them according to the law. So your brother is not your close relative and not your close person, family member. I didn't even think that this is a document of strict accounting principles. That's my question to you. Why I'm asking you this question? Regarding your mother, you indicated that you don't know your place of location. It was the year 2022. In the year 2021, the wife of your father issues the power of attorney on your name of your brother and your mom. That's the year 2021. In year 2023, you gave a power of attorney to your mom and give her a right to sell 1/3 of apartment. Why? In the documents which you submitted to the military unit, you indicated that you don't know the whereabouts of your mother. Maybe it was related to the fact that in 2022, in the beginning of the full-scale invasion, actually it was absolutely a chaos, and living circumstances were so difficult, and the mom who lived at that apartment, who had lived at that apartment before, she already couldn't stay there anymore because there were constant shellings, so she needed to change her whereabouts all the time, her place of residence all the time, and maybe, and correspondingly in that context, maybe I didn't know what place of residence should I indicate there, because I didn't know where she lived, because she constantly changed her place of location, her place of residence. Were you not in touch with your mom? Didn't you take care of your mom, or wasn't you worried about your mom? No, of course I was worried about her, but I didn't recognize the importance of these documents and the data which. So shall I tell you as a military person the status of the document and why it's filled in? Yeah, I know it. I know. If I'm not mistaken, I indicated there is a mobile contact number. No. Regarding your mom, you didn't mention anything, and you also you neither didn't mention contact details regarding your father. The only thing that you mentioned is that you don't know her whereabouts. So you knew about her whereabouts in 2021, 2023, and it could be confirmed by notary documents that were issued, but in 2022 you somehow failed to indicate it. What was your goal? There was no goal at all, no purpose. But why you mentioned your father, and you didn't say in the documents that you don't know the whereabouts of your father? You know, for me it's quite hard to comment upon the document which I don't have at my hands. But the issue of that mobilization, which took place in October, it was so quick, it was so rapid. All procedures, I passed all procedures so rapidly, the medical commission and medical exams and so on. So you have passed the medical examination in the conscription office. I don't know. You have said that you passed some procedures. What else, apart of the medical examination, you have passed? So first of all, there was clarification of the data in October 2022. I mean the following, that the medical examination is a process, is a procedure which consists of some stages. Yeah, I know, I understand everything related to the military service. That's why I'm specifically asking you about it. And what you are telling to us, it's, it doesn't comply with actually what has happened in reality in 2022, because I have been at the army since 26th of February 2022. That's why I know what has happened in the beginning of the full-scale invasion, and what you are telling to us right now, they do not correspond to the reality completely.
I can comment on where I was and what I saw. Let's put it that way. Back then, in 2022, I had some work about which I was very enthusiastic, and it was a very cool work. And I have also provided the Commission with some public communication regarding what we were doing. And basically, I was living there. I do not remember what and where I was stated by me in which document. Okay, what is reputation for you? How do you understand it? Reputation is goodwill. That is the totality of some information about the person which describes this person. First of all, that is about actions, about active actions. Is your reputation important for you? What other people think about your reputation? Is it important for you? Of course, yes. At the same time, among other things, within the framework of some activities and performance of my functions, including as the attorney, as the defense attorney, yes, there are some instances happening which your opponent or some other person can dislike at the subjective level. And I do not think that this is worsening of the reputation, etc. Okay, thank you. And my last question to you. Can you please tell us about your participation in combat actions in the armed forces of Ukraine? What combat operations were you performing and where? I've provided a document that within the body where I was serving, I was delegated to territorial management units. In which city did you serve? Mostly that was Zaporizhia and Zaporizhia region, and the last period of time it was Kiev. And the Center of Innovations is located in Kiev or in Zaporizhia? Of course, it would be more comfortable for me to answer this question in a closed mode. I'm not asking you about a specific address, I'm asking about the city. During my service in the Innovation Center, I was delegated initially with the order of the head of this military unit, further delegated to which town? Tactical Group Zaporizhia, which was performing its activities on Zaporizhia area. What were your functional duties? I would like to close my idea that I started before. Further, it was combat instruction of the head of the general staff, based on which specific orders on delegations were issued. I think I provided that among documents, and it delegated me to Zaporizhia unit that was responsible for Zaporizhia direction. There was a specific purpose of the trip. You should not mention that. Okay. And subsequently, within the intelligence unit, I was delegated to the combat units that were performing their activities on the territory. Okay. So you were supporting activities. You did not take direct part in hostilities, you supported their activities. Right? Well, it is difficult for me to answer that during the broadcast. Okay, thank you. That was work, among others, related to UAVs, air defense, and intelligence activities. Okay, it was important work. Okay, thank you. Colleagues, sorry for taking so much time, but these were important questions.
And to comment that all the questions regarding integrity which were discussed in our previous interview, we will not repeat it because you responded to those questions and also responded in written. So we will not come back to those, and I think it's not effective as we talk about effectiveness today. We are discussing only these aspects that have been revealed recently or additional aspects. So with regard to this, I would like to ask about administrative offenses. Last time we discussed that you had a number of offenses related to traffic rules, and I probably would quote that you told us that you were kind of shocked when you saw the actual number of these offenses, and now we've got information, correct me if I'm wrong, that after in the period between our interviews you've got 2 new situations with the breach of traffic rules. Am I right? And what are the circumstances? How would you explain it, and what is your comment on this?
Да, мені
Yes, it was very unpleasant for me as to what happened. After the last interview, I'm trying my best to adjust my conduct behind the wheel. And every time, once I receive these penalties from this automated system of traffic system, it caused negative emotions inside me and anger at myself. As I always thought, once this automated system records, I thought that I was moving with the same speed as everyone. All the traffic violations and penalties, I pay all of them on time, and I'm ashamed, very ashamed, and I'm undertaking the commitment to correct my behavior, not only in connection with the work of the inspector, but in general, in order to avoid such situations further. Thank you.
Do you have some 1 or 2 additional questions, not more, because we are exceeding our time? Yes, please.
Actually, this area was also of my interest, but I will phrase now, after my colleague's question, I will phrase it differently. As the head of the future Service of Disciplinary Inspectors, if you had a case of someone who violated rules, the person would tell you, yes, I admit, I'm very sorry about that, I was shocked. And then, in quite short amount of time, this person would do it again. How would you evaluate such behavior as the head of the service?
Again, we are talking about several aspects. Of course, the basic one is about trust, distrust. And once some actions are committed, the person takes some commitments, which the person is obliged to perform according to the law, and fails to do that. And of course, it shows that the person violates this basic fundamental quality about trust. At the same time, I understand that there are many contextual aspects, some events, and with respect to traffic rules, it is necessary to take into account whether there are affected victims, other participants, some people who were harmed by some unlawful actions. And it is necessary to take into account the general context of why the person is doing that. And of course, all of this should be taken into account while making the final decision. At the same time, as I think, and based on the practice that I've studied, among offenses with respect to the Code of Ukraine on administrative offenses. For example, Article 130 with respect to drunk driving. That's it's enough to have one violation in this case, and that one violation is enough for dismissal of a judge from the position because it is a gross violation of ethics. But again, it is necessary to analyze whether this violation reaches this minimum level to be qualified as a disciplinary offense. Similarly, there were many questions whether all violations of ethics are sufficient for disciplinary liability, and of course the general answer is no. We need to take into account the context, negative consequences, and the degree of the violation. That's it. Thank you.
In the context of our competition, if the repetition happens in such a short period of time, and before the repetition we hear a kind of promise that it will not happen again, and now we again read or hear a promise that will not happen again. It's a conceptual question for me rather than personal. Is this, in your view, a contradiction between words and actions?
Я не відмовляюсь.
I do not abandon the promise that I made, first of all, with respect to myself, and I'm deeply frustrated and dissatisfied with myself that it happened like that, and I understand factors why it happened like that, not because I was some marginal and systemic violator, no. In your thoughts, you are in some reflections, you are in a hurry to get somewhere because you have many duties which you undertake on yourself. So that's rehabilitation and adjustive period outside, regardless of the results of this competition results. It's the duty that I have to fulfill. So thank you for your question, and thank you for highlighting this for me.
Thank you very much. We are not running, but we ran out of time. But it was important to ask questions that were the most important and to give you an opportunity to explain. And now, if you have some final comments, just 2 minutes, if possible, not more, or you don't have. So it's totally fine not to comment.
I would like to thank you for your work. I am especially grateful to our foreign members of the Commission because that's really valuable that you take part in this competition and that you help build the service of disciplinary inspectors. Really, your contribution is of high quality and valuable, and regardless of those difficult and harsh questions that I was asked, and I have to admit that if I had the opportunity to come to you for the third time, I would come to you for the third time, even regardless of the difficult questions. These were correct questions. I believe that these questions should be discussed and asked and communicated. They have to be clarified. And I think that this interview has been really valuable for all the participants of the interview, and I wish you success and energy in selecting the best candidate who can really build a new quality institution. Thank you.
So, yes, the decision on the winners will be announced on Wednesday. So thanks again for coming and having this interview, and good luck. Thank you. Добрий день, good afternoon. So now we will have the interview with Mr. Alexander Volodymyrovich Krotenko, candidate for the position of the head of disciplinary inspector service. So, Mr. Krotenko, our interview will be conducted by the selection commission, which is in its entire composition today. I'm Reda Molene, the chair of the commission, and the commission members are as follows: Yulia Bokova, Olena Kovby, Olha Popikova, John Ehrlich, and Pavel Zhelinchik. So our interview will last for about 60 minutes. It can be prolonged as it was with previous interview if we have some additional questions, but approximately it's 1 hour. And we will ask some questions about your professional competences, skills, and regarding also managerial competences. And at the second part of the interview, we will be asking some questions regarding your integrity. And also, I would like to inform you that the interview is broadcasted, and if you have any information which falls under restriction for its public disclosure, according to the martial law, please inform the commission during the interview, and we will take a decision accordingly. Before the start, I would like to ask, maybe you have any questions, requests regarding composition of the commission or some other requests?
Thank you for giving me this opportunity. I think that for now, there is no single need for such limitation, but if there are any questions regarding military service, of course, I inform you about any presence of professionals or state secrecy.
I'll give you a floor to present your vision, your understanding of the service, how you envisage of building this service, and you have up to 10 minutes for this. After that, we will have this session of questions, and at the end of the interview you will have several minutes for your final comments. So the floor is yours for your introduction. Please proceed.
Thank you so much, dear Chair, dear Commission members. I'm thankful for this opportunity to be here, participate in this competition. Regarding motivation, first of all, to participate in this competition, being at the army, first of all, of course, we fulfill those tasks which are put in front of us by our commandship, by our leadership, and the participation in this competition is not a priority for service persons. But given that the previous competition failed, and also because of one of the reasons, because the number of candidates was so limited, I made a decision for myself. So first of all, I reached out to the head of the my military unit to get an approval, and I made a decision to participate in this competition with the only purpose for this competition indeed to take place, because the number of candidates is limited, and for such position it's not actually clear why indeed people who are decent, who are worthy of such position, why they didn't participate in this competition, why didn't they apply for this position. Maybe at the previous stages the level of requirements was so high, but I think not, because I participated at the previous stages. I can't say that they're extremely complicated. So I have worked in the HCJ so from 2017 to 2021 with the short pause, and based on this experience, I can say that our inspectors were so professional. Some of them keep working at the HCJ, others stopped working at the HCJ, but among them there are so many indeed decent candidates. That's why it was one of my motivations to participate in this competition. Regarding the mission of the service, to my opinion, so unfortunately I don't know why there is such an such an understanding that an inspector is only an assistant to the member of the HTA. So for now, the position of those secretariat members, they had a task only to draft the findings and rulings of the decisions of the HTA members. Of course, so that's a key part of their functions, but I think that for the new service, the new role of the inspector, their mission and their vision, if they see that there is any problem, they should be vocal about this problem. They should express it out. So the task of the inspector not to draft those rulings, hundreds of rulings, thousands of rulings, mentioning those articles which are so well known to many people, including complainants. Our complainants are so professional. Sometimes they are attorneys.
So that our interpreters would be able to translate
Вибачте,
everything.
трошки емоційно.
Thank you very much. Just a little.
So I'm a little bit emotional. Sorry. So, to my opinion, to my belief, the role of a disciplinary inspector, a new role, that's to form the practice, the case law, because the previous experience which I familiarized myself with, they were prepared by the former inspectors, as far as I know, as they are now secretariat employees, and that also was part of my job. And what I drafted right now, it was also generalized and general documents. But for now, as far as I understand, the inspector will perform a role of a producer of the disciplinary practice. So the game will be on their side, the ball will be on their side. What they put in their conclusions, it will be verified by a disciplinary chamber. If an inspector decides to conceal something, to hide something, a disciplinary chamber cannot verify those conclusions. They can only return it back, but they cannot do this work for the disciplinary inspector according to the Constitution. Disciplinary inspector should do this role, should verify all those, verify this practice, unify this practice, and all judges who have integrity, they do this work, and if they don't know how to interpret this or that provision, they also reach out for explanations, reach out for this accumulated generalized experience. Here now I'm speaking about decent judges with relevant integrity level. Secondly, regarding the role and functioning of the service, so yes, so it will consist of new employees and from private sector such as attorneys, lawyers, and also those who were already before in the HJ. Among inspectors there will be also former judge assistants and so on. I think that such composition will allow to fulfill all the tasks which will be in front of the service. Thank you so much.
So you already have some experience of working at the High Council of Justice with disciplinary cases as the inspector, but as you already said, in a bit of different capacity, as more like an assistant to the member of the High Council of Justice. You haven't participated in the competition for the position of the inspector, have you? No? You didn't participate in the competition for the inspector's position. So my question would be, as you said, the new capacity of the inspector is much more autonomous, independent, and important for the formation and of the practice of disciplinary cases. But you didn't consider this as a wish for you, as a career step for you. You would like to lead the service. So how would you explain or comment on this choice, not to be the inspector, but the head of the service? And as we have a requirement for our candidates to possess foreign language, knowledge of foreign language, I would kindly ask you to answer this particular question in English. Thank you.
Thank you. This position, head of service of disciplinary inspection, as for me, more important than other profession, as a lawyer or advocate or some state serviceman, and the head of service of disciplinary inspector main person in this inspection, and he or she must be allowed the main course of this inspection, the main thought what will be done in this inspection or not to be done. Thank you.
You consider this position as empowering you to create the whole inspection and to create a new, like a body, and not just to be a part of the particular capacity as the inspector. Am I right? This is your motivation to go for the leader of this inspection and not to go for inspector, right?
Yes, thank you.
Okay, thank you. I will later proceed with my questions, but now I would like to give a floor to our commission member, Yulia Bokova. She will
Добрий
start
день.
the session and we will proceed. Thank you, Yulia.
Добрий день.
Good afternoon, Mr. Alexander. Good afternoon. I have the following question to you. In the motivation letter, you specify that organization of the work of disciplinary inspectors consists in the determination of clear plans of work, in my opinion. Can you outline these plans of work that you plan to perform at the position of the head of the service of inspectors?
Tanya,
Thank you for your question. So first of all, the clear and well-defined plan of work. So first of all, that's formal requirements, because each of disciplinary inspectors will be a civic servant. It means that he or she will be covered by provisions of the law on civil service, and it should be also carried out a relevant yearly assessment. As far as I understand, theory assessment will take place at the end of the next year, and it will be a precondition for dismissal of such disciplinary inspector if he or she fails to comply with provisions of the law on the civil service, according the conditions and requirement of the of this plan of work. So regarding statistics, there is a budget program of the HCJ published on the website of the HCJ, in particular for the years from 2025 to 2027. It consists of some plans on the number of acts that should be issued by different state authorities, including HCJ, so it's planned already for several years ahead. I familiarized myself with those figures, and I was surprised at the huge number of documents which was actually planned for disciplinary inspectors, including, for example, acts on completion of disciplinary proceedings. So it's planned to have 25 per each inspector per month. I'm not sure that you know that you can't. I'm not sure that you can. You could qualitatively work on 25 acts for one person per month. It means that such person should be extremely effective. The performance should be very high for such acts, for such documents, not to be returned for additional finalization, additional work to be done by disciplinary inspector. Also, next year it plans that 4,200 decisions should be issued without consideration. So it's a huge number for 25 inspectors. This number is not enough for this planned work. I don't know who planned this work, by the HCJ members or by whom. I think that some work was done before this plan was issued. That's why I mentioned in my motivation letter. So first of all, those plans of work have the formal aspect and the actual aspect. So what is planned and what we will strive for. Because I think, it's impossible to fulfill those figures. 25 inspectors and we will have so many per month. I think this figure is too high. Okay, tell me please. You mentioned plans published on the website of the High Council of Justice. For example, let's imagine a situation. You are appointed for the service of disciplinary inspectors. There are so many different cases, new premises, new team. What will be your initial steps and initial proposals regarding optimization, how to optimize the work and how to effectively launch operations of the service of disciplinary inspectors? Thank you. Thank you so much for your question. So first of all, of course, it's to define how to automatically, the procedure of automatic distribution of such cases among disciplinary inspectors. We shall understand what we take as a criteria, the criteria of professionalism or criteria of equal balance in terms of cases. How we can understand whether one inspector is more professional and on land law, another on criminal, and the third one, for example, on some commercial things. So I think that we shall distribute the number of cases among disciplinary inspectors and then understand what are the heavy cases, what are the more difficult cases. So there could be different criteria how to identify a case to be a difficult one. We understand that there are so many complaints which could be quite simple ones, so they could be done on the template and so on. We need to understand how to do it. We need to sort them, to range it, those 10 or 12,000 of cases, which are heavy ones, which are not. So understand those who have less cases, maybe they will need some help in terms of the difficult cases. So we shall go according to the plan, which was identified by the HSA, 25 decisions per month. If an inspector fails to do this plan, then we shall identify why, objective or subjective. Objective, okay, we need to understand that we can't change those conditions. Maybe subjective, maybe this person has a low level of salary or takes sick leaves very often, and then we need to redistribute such cases among other disciplinary inspectors. That's the first thing. Second, so the regulation on service has been already developed several years ago. It was quite a good one. Of course, legislation has changed. Now we need to actually draft this regulation from the very beginning, from the scratch. But those issues that were on the table, for example, on recusal or self-recusal of disciplinary inspectors, they were already challenging issues. I think that we need to include them into this regulation and, of course, to approve them on the meeting of the High Council of Justice, because if inspectors decide by themselves which workload they're going to have, we will never deal and complete with those cases that we have right now. Regarding the premises, my third proposal, in 2020 and 2021, when the pandemic was widespread and the HCJ Secretariat worked remotely mainly. So remote work at that time was mainly in the following. So when work was given, assigned to the inspectors, but mainly people worked at home. Yes, only a small number of people worked at the office, also including to comply with the pandemic requirements. So I think maybe there could be possible consideration of such remote work for some people with maybe temporal visits to the office. If an inspector can show what was his or her scope of work from home, then it's not a problem where to work, from home or at the office. And as actually it's important to comply with the ethical standards and as it's required. Thank you. Dear Alexander, can you tell me about your managerial experience? Yes, thank you. Actually, I planned to do it in my presentation. My managerial experience consists of two parts. First of all, I started my career in such organization that's the International League of the Protection of Rights of Citizens. I worked till the year 2006. I started there as a lawyer's assistant, and then in 3 years I became the head of the director of the legal department. Actually, 8 or 9 people were under my subordination. They were lawyer's assistants. They gained experience there. We had very good internship programs for our students. After those internships, they became either legal assistants or interpreters, or maybe they completely changed their career and became psychologists or civil servants. But anyway, all those people who were interns in our organization, there was quite a high number of them, and I was the deputy director of this of the department. So the organizational structure was the deputy director and the head of the legal department. So we mainly worked at the human rights sector. We worked with the complaints of the convicted persons. We worked with complaints against actions of judges. We protected interests of those who asked for our support. So all this work was done by our organization. I had the right to sign letters. I generalized the practice of our organization. For example, we received a complaint. I understand that we understand we can help, and we write a letter on behalf of the organization. For example, a mom who has a problem with nursery and can't get a place at the nursery, and that's how we help those people. And that's for this work actually I received the right to practice law. That experience, managerial experience, lasted for around 2.5 years. Now also I'm at the army. By my position, I'm the head of the group of psychological support and recovery for the battalion, and that's a managerial position. Before that, I was the deputy commander of the company, and I didn't have any, so I had quite a lot of persons under my supervision. Thank you. Tell me, please, about your professional experience since the beginning of 2021, when you dismissed the position at the HTJ. After I was fired from the HTJ, I registered in the employment center, and then in 2023 I started to work at the army. So I had 6 months more to be registered in the employment center, but I understood that my role as a lawyer, my position, so I need to help them, and I renewed my certificate to practice the law. And in 2023, I worked very actively, full time. I provided so many consultations to different clients. I was involved in so many different court proceedings, so much more before than it was full-scale invasion. What was a key category of cases you were involved? Consultations on mobilization, consultations on the military service, pension legislation, social protection. Then there were also some cases related to the defense at the commercial courts, some debits and debts affairs, so some different things. At some moments, I even had so much work that I couldn't have any possibility to have several clients in parallel. I needed to refer them to my colleagues. Okay, tell me please, have you reached out to the High Council of Justice with complaints against judges? Yes, there was such a case. This was in 2017, before I worked at the HCJ, and my complaint, this complaint was against a judge on omission of actions of a judge, and this judge of Shevchenkivsky District Court. And so this judge actually considered the complaint for 33 days rather than 3 days. So she made a decision, but actually it took her 33 days. She understood what decision she is going to make, and it was very clear. And the issue was related to the freezing of the temporarily seized property, and I represent the interest of one of the companies. So the search was taking place at the house, but at different premises, not the premises that where search should be done.
Thank you. I have no more general questions. If you have any questions about professional competence, please. Hello, Mr. Alexander. I have several questions to you. My first question is the following. Can you please tell me if you positively pass the competition and you are appointed to the position of the head of the SDA, what would be your first steps and how would you build your cooperation with the HCJ? Thank you. The question is very good. As you probably know, we have an unresolved issue. In my opinion, I was not paid the benefit for the service. My first steps before starting working at this position, I would offer the reconciliation agreement, and I think so that we would cooperate with those employees who would accrue salaries to us, so that we could effectively work with the financial department, with the secretariat, with the workflow department. I know all of them. As far as I understand, apart from the head of the secretariat, almost all employees are the same. And back then we had effective cooperation, and I think we will have effective cooperation now as well. Sometimes we tried resolving those issues that emerged. My first step probably would be development of the regulation and taking into account the criteria for the complexity of cases, because each of the cases takes some attention, and we understand that some cases can be processed within 2 hours, like in our practical assignments, but some cases will require just several days. You have to sit down and draft a justification, and we already have those standards that are set by the HCJ. Those decisions, for example, that we can see at the website of the HCJ, there are 70 pages in one decision, and should this decision have 70 pages, and that the disciplinary inspector to decide. But these 70 pages required that the judge would be subject to a severe reprimand. I believe that, just a few more words, I believe that those criteria that we are talking about are necessary. Maybe they should be developed in cooperation with the civil society organizations, because, for example, some issue is more important for us, but for civil society organizations believe that integrity issues are more important. There was, for example, such a category of cases as judges of Maidan, maybe Crimean judges. All of these issues have been accumulated, and they should be resolved right now. But just to write 4,200 rulings without consideration, no. I don't think we should prepare rulings without consideration. But even though they are also needed, so that judges would know what to expect from the new SDI. In any case, they will perceive it as sort of a channel body, but I believe that judges will try to help us. So that's methodological recommendations that have already been developed, and we will try to develop together with the Secretariat of the ACJ, will be a guideline for judges. Once they will understand that these actions are punishable, these are maybe punishable, and these actions are legal and relevant, proportionate. So also I think that there will be a short period of time to understand the situation, the context, and everything that was previously mentioned by candidates for the position of the head of the SDI. I know about this, and I understand what I will do on the first day. I understand that it will be like item 1, item 2, item 3. I will develop the regulation, I will meet the team, I will explain our actions, and I will wait for the feedback. And I understand that most of the candidates have never worked as inspectors. Maybe they do not understand the peculiarities of work. Maybe they do not understand that there might be pressure, but they should be explained on how to properly respond to all of this. Okay, thank you. Do you understand it correctly that your first step would be, in case you are appointed for this position, will be resolution of your personal financial issue? No, absolutely no. That's needed in order to settle this issue. I will suggest the reconciliation agreement just to close this matter. Okay, and if the HCJ denies in that to you, so once the case is considered, then it is considered. I don't know. It's very strange that you've mentioned this particular aspect as a priority one. I know that some members of the Secretariat are concerned about this, so I just want them not to be concerned about that, and that's it. Okay. The first item that you've mentioned as the head of your of the SDI is adoption of the regulation on the SDI. Is it included into the powers of the head of the? I meant development of the draft regulation. Of course, the head is not adopting the regulation, but the head has to develop the draft regulation. Where is it stated like that? That the head of the SDI develops the draft. That is Article 29.3 of the law on the High Council of Justice. So you will be the one developing it, and what's the procedure then? I will submit it for consideration of the High Council of Justice. Okay. Can you please tell me what do you think about the situation when the head of the SDI performs the role of the inspector at the same time and has cases in proceedings? Thank you for your question. Negatively. So you are not ready to perform functions of the head and to be the inspector at the same time. I will explain my position and I will answer your question. Back in 2018, the group of inspectors, almost all inspectors, were invited to a training to Romania on the topic of disciplinary responsibility of judges. We learned about the work of inspections in Romania. What I saw there, the head is not dealing with the consideration of complaints. The deputy head may do that, and the inspector is doing that. And the head has legally determined powers. In my opinion, it does not set out the right of the head to consider complaints. Okay, in continuation of this topic, if the Council of Justice adopts the regulation or develops the regulation on its own, and this regulation sets out that the head of the SDI will perform the role of the disciplinary inspector, what would be your actions? Would you continue participation in the competition? I will follow this decision, but at once I will have a question about the coefficient, because of course the head cannot perform the same functions as the inspector at the same level. What coefficient would be okay for you? I thought about this. Some unreal figures like 0.1 thousandths of the percent, of course, I will not talk about that. Maybe 40-50%. 40-50%, okay. And my last question, you are a service member right now. Where are you located in terms of territory, just the city? The permanent location is Semenivka village. Okay, just, okay. And where is your military unit located right now? Mykolaiv region. Okay, Mykolaiv region. In connection with this, based on which ground are you in Kiev right now as a service member? Upon permission of the head of the commandment. I'm delegated here to be here. Okay, no other questions. I have the official permit to be here. Okay, let me ask some questions. Good afternoon. I have one question to you. Of course, candidates submitted motivation letters, and I believe that this is good because we have the opportunity to get acquainted with you even before the interview. I have a minor question to you based on your motivation letter, in which you specify that it is not a secret that most complaints are rejected at the stage of preliminary check, and no one knows about the essence of the complaint apart from the inspector or the specialist, and as a result complainants have to repeatedly submit the same complaint to the HCJ, which causes distrust of citizens to the institution in general. That is a quote for your motivation letter. As far as I understand, you basing this idea based on your experience when you worked in the HCJ. At the same time, today you are the candidate for the position of the head of the newly established service. Can you please tell me, having your experience as the inspector in the HCJ and understanding the place, vision and role of the newly established service, how do you see solutions to the issue that you raised in your motivation letter? How this tradition can be changed? Thank you for your question. The first thing that I would like to say is that independence of the disciplinary inspector is probably based on compliance with the provisions of the legislation, or taking into account the generalized practice of the ACJ adopted at the meetings of the ACJ, because one of the duties of the inspector is to fulfill decisions of the ACJ. So accordingly, if there emerges the situation that I as the head see that some inspector, probably it will be 1-2 persons, I don't think that it will be a huge problem, significantly evades fulfillment of this practice, application of current legislation, then of course with respect to such an inspector I will raise the issue of disciplinary responsibility of such inspector, because I know about such instances. For example, a judge applies the provision of law that is favorable for the judge in this situation. For example, that became invalid 4 months before adoption of the decision. And once the HCJ member sends a request and asks, please explain your actions, he says, I did not know about the change in the legislation. Of course, such actions should entail disciplinary responsibility, especially if these actions are committed several times, because the head will see all the opinions prepared by the inspector. And of course, there is the human factor as well. There may be some excessive workload, but if the inspector systematically returns complaints, which the another inspector considers as justified and recommends for opening of the proceeding, then we have a question about the professionalism of this inspector. Maybe this person is a great lawyer, but should learn more to become the inspector, or maybe we can even talk about sending this inspector for some additional training. I believe that we will have these cases. And I wish that the most of the inspectors to be selected right now, and the inspectors would stay there in a year or in a year and a half, because I'm convinced that maybe not all of these inspectors realize the peculiarities of the work. Alexander, one follow-up question. So, understanding that preliminary consideration of disciplinary complaints is really important because preliminary consideration of disciplinary complaints is to be performed by the SDI. And you are aware of this, you are emphasizing this, and at the same time, do I understand your idea correctly? That sort of a revision by the head of the SDI is envisioned. I mean, like revision of some opinions or regulatory documents that will be prepared by inspectors. You can call it like that, but I would call it some generalization of the practice. Because colleagues at our meetings will have to know, for example, some novelties in the legislation, some amendments to the legislation, or how some inspector resolves some problem or some situation. And I think that sharing experience with colleagues is valuable, and it's better than just to merely study the regulations. I'm sorry, maybe I disagree with you a bit from the perspective of me understanding the scope of documents, whether the head will be able to control of that personally, because that's a huge number of documents, and to review all of them is difficult. But I agree that the preliminary consideration of disciplinary complaints is really important, but that's some food for thought for the future. Okay, thank you.
I would like to ask you this question. You mentioned when you are describing how you envisage how to create, how to build this this new office, organizational aspects of it, also drafting regulation, solving issues on remuneration, all those things that are very important in building the structure. Coming from this, my question would be, which skills, the most important skills that are required to build the institution, you would think you have, and that which make you the candidate which should be considered as one of the best.
Дякую. Дякую. Ну, перш за все.
Thank you. First of all, I believe that those qualities that a candidate for the position of the head of the service should have include the following: analytical thinking, ability to manage the team, ability to work with people, that's also very important, ability to set priorities, integrity, independence, ethics, ability to communicate with representatives of the civil society, especially in case of some emotional settings. For example, it's not always possible to explain your position to people without special legal knowledge, and the ability to explain everything in a simple way is also the task of the head, because the head will be addressed in case of any problems, and mass media, journalists will address the head, and the head will be able to work with the mass media to explain the position clearly and to defend interests of the service while according to the law. So it is also necessary to clearly know the law.
You described a very complex list of skills and competences that are required. So you would think that in principle you possess all of them as a candidate, right? So I would like to go deeper into those skills and competences that are related to ability to work with a team, with people, to understand, to communicate, those interpersonal communication skills. What experiences and maybe some situations, particular situations in your previous or current capacity would prove us that you possess this kind of interpersonal communication skills and ability to prevent and solve conflicts effectively, etc. Could you please give us an example of this? Thank you.
Thank you for your question. I would like to say that actually during military service it is impossible to somehow resolve the task without interacting with other service members. For example, once I held the position of the deputy head of the commander, in my subordination I had quite many people, several dozens of people. And these people, there was not a specific list of people. These are people who live around you. You live together, you serve together, and you are obliged to perform tasks together as well. I will not be able to perform all the tasks on my own. And as you know, mobilization in Ukraine includes mobilization of completely different people. Of course, they are selected based on their qualities, but these are completely different people with different life experience. Maybe some of them do not feel as a part of the team. Maybe some of them want to be leaders even though they are not leaders. And you have to find approach to each person. Frankly speaking, not always I have managed to do that. It's difficult for me to say that of course, I'm not the commander. I cannot be the commander, but I can be the person who unites all of these links, like commanders of units. In addition to being the deputy commander of the brigade, I also had the acting head of the assistant of the head of the legal service, and I performed this work for almost a year. And this lawyer of the military unit envisions interaction and cooperation with completely different people, completely different services, with different subordination levels. Some of them are much higher in terms of their military rank and title than you. And understanding my responsibility, in particular for defense of the interests of the state, you have to interact and work with everyone, with different people of different ages, of different social statuses. And I believe that I've managed to do that, and a confirmation of that is numerous letters of gratitude that I received from commanders, for example, commanders from South Commander. And I believe that my current title, the head of the psychological support unit, confirms my words.
Thank you very much. I will now give the floor to colleague John, please.
Dobry den.
Доброго дня.
You were asked a question about first steps, and you listed a number of actions that you would take, working with the employees at HCJ, develop regulations, work with civil service organizations, and then you said develop guidelines for judges. Can you explain more fully what you mean by developing guidelines for judges?
Thank you. Thank you for your question.
So, I'm thankful to your question. Indeed, it has some background. When I was appointed for the first time the position of an inspector, it was considered, maybe it was unofficially considered, that we work. So an inspector, for example, drafts the decision. So he or she works for in the interest of a disciplinary chamber or a member. So to bring or not to bring to disciplinary responsibility of a judge. So maybe there should be a responsibility of whether this decision is indeed approved or not. But at that time, 2016, 2017, judges didn't have those clear criteria which actions should be subject to discipline, which not. So I remember those cases when it was unclear what a judge should have done at that specific situation. There were questions without answers, and disciplinary chamber didn't have answers for those questions. Of course, after the consideration of a case is over, how a judge should have done. So there is a law says like this, and there is generalization says another thing. But so, for example, a judge says, I base my actions based on the generalization of the case practice, but the law says different things. So it was then clear the generalization of the disciplinary practice should be done, then it should be approved by the HCJ. And as far as I have seen, those generalizations, those unifications were made, they were done in a quality manner. You can work with them. They are divided into different sections, and indeed those judges who use them at their work, I'm sure they comply with their provisions. Those who read them, they know how to apply those norms. Those who don't, unfortunately, make some mistakes, and it leads to the dismissal of judges sometimes. Did I answer your question?
So I'm trying to determine if those guidelines would have the enforceability of law. In other words, are they simply examples, or are you stating these are the clear rules? Because we have the Bangalore principles, we have legislation,
Yeah.
we have the code of judicial conduct,
Yeah.
and we have case law. And now you're suggesting another source for disciplinary guidance or disciplinary liability. And I'm just wondering what enforceability or authority those guidelines would have.
Я вважаю, це не буде видумуванням певних норм. Ну,
I think that's not about creation of some new norms. Yeah, indeed, it will be a case law or a practice of the High Council of Justice formulated in a relevant manner, in appropriate manner for a judge to read about those things, to make a relevant, a lawful decision. No, not to make up any provisions. No, a discipline inspector can't tell judges what to do, and no one is going to ask a discipline inspector to think about or to create some rules. If an inspector wants to do it, they can draft an article and defend a dissertation on that matter. So what shall be done by a judge, what is not provisioned by the law? Maybe to develop a new normative act. That's a right, a discipline inspector to work as a scholar, but it should be a scholar article rather than instruction to a judge what to do or what not to do.
Thank you.
yeah.
Referring to your motivation letter, you stated as follows: the emerging problems of the judiciary should be resolved by the judiciary itself in an acceptable manner, including with due regard to the HCJ's disciplinary practice. Therefore, this imposes another special mission on the future members of the disciplinary inspectorate. Participation in the development of law enforcement practices. What did you mean by that?
As for me, насправді,
Actually, the role of the HCJ, to my opinion, as the candidate for the position of the head of the service, that's about to help, specifically help judges to administer justice. There should not be a case and HJ is perceived as a punitive authority, as it was before, as it was with the High Council of Justice before. So unfortunately, this practice had been developed for years, and it's so difficult to mitigate it. So if I'm recommended to take this position, I would try to do my best to simplify job of judges, not to make it harder, but for them to understand what they could get if they commit some actions or if they omit some actions. So how they should act, and HJ should help them how to behave with integrity rather than to create obstacles which may be not envisaged even by the law.
And how would they do that? How would they help the judges in that fashion?
Для суддів, я думаю, це
I think that for judges, it will be of more help if the service of discipline inspectors develops such unified case practice and each time gives the relevant case practice for 6 months, for a quarter, maybe for quarter it will be not enough. So each 6 months the service could provide generalized accumulated information which constitutes interest for judges. Of course, not everything would be of interest for judges, but if judges reach out to actually to the service of the HCJ, so the service of discipline inspectors could try to help such judges in terms of generalized information.
What type of generalized information?
я думаю,
I think that it will not need any additional efforts in terms of time. We anyway do it. So a discipline inspector who is interested in practice, in work of his peer colleagues, he is obliged or she is obliged to familiarize themselves with the practice of the Supreme Court, of the High Chamber of the Supreme Court, of other colleagues, of other authorities. So we need to familiarize themselves with it because judges issue their rulings. And according to our legislation, according to our key law on the judiciary system, so it says that the decisions and the rulings of the High Chamber of the Supreme Court are mandatory for fulfillment by all judges.
Are you, okay, I think I understand. So education on the decisions of the High Court, is that what you're suggesting be provided to judges?
так, освіта й само.
Yes, so education, self-education, that's actually a foundation for our professional development, both for judges and inspectors.
Дякую.
Дякую.
Thank you.
I will start my set of questions with one regarding your professional career. And there is one thing which is interesting on the list of your employments, which is there are quite many of them, and your work for those companies or entities was rather short. At least that's my reading of your resume. Is it a correct observation that there are quite many, and you stayed there maximum 2-3 years and sometimes only several months?
Ага. Я поясню. Справа
Yeah, I will explain. When I worked as an attorney, I tried to work with so many different companies which actually required my services based on the labor agreement. Usually it was project-based involvement, project-based employment. I can even give you some examples of companies. We have some such as TB company or Nova Poshta or any other companies, any other entities. I would like to say that those entities had some project-based activities, and I always insisted not only to have an agreement as it's envisaged by the advocate sector law, but also by the labor code. Why do I need it? For example, in order to avoid any risks. For example, to avoid risks when your employer indeed pays you your payment for the services you provide, because sometimes it happens not only in Ukraine but in other countries, because the advocate, the attorney, doesn't want to provide services pro bono and don't get any payment for them. That's why, answering your question, when I provide with my service as an attorney, I always tried to sign not only an agreement on provision of attorney services to them, but also a labor agreement with them. Yes, indeed, those projects were not that long, 3-6 months is like this.
An attorney, but also employer of that entity?
я
I worked as an employee, so yes, I I fulfilled the function of an attorney, but also I was an employee there. It's allowed by the law, and actually it's always better for the head of the entity when such a lawyer has an attorney certificate. It's not forbidden, and also according to the practice, according to the law, usually don't have any other clients in order to distort the essence of such labor agreements, because here we should have such relations, employer and employee.
Answer. My follow-up question is, but you didn't stay there longer with those clients. So it only was for the project, as you mentioned, and then it was done, and the cooperation with that particular entity did not continue.
Да.
Yes.
Of what?
Складно сказати.
It's hard to say. Of course, sometimes there were cases when in several years those entities returned back to me. Yes, there were some cases, but you know, when you work with someone, the project is over. If there is no new project, business doesn't have the necessity to spend time and money on you.
Second question is very abstract, very conceptual, and I will not grade you like in school, so you can feel free. I just want to see how would you think about this question. In your opinion, if you see the two terms, judicial ethics and judicial integrity, is ethics part of integrity, or it is the other way around and integrity is part of ethics?
To my opinion, the essence of judicial ethics is based on our understanding of the law. If a person is appointed for the position of a judge, and this person understands correctly the provisions of the law, always follow their own beliefs or their own inner beliefs and values, and following the norms of the law, that's the sign that this person knows the judicial ethics principles. And all those norms of judicial self-governance, of the unity of judges, all those norms are important. But each judge is important, because when you consider a disciplinary complaint, it should be clear that, for example, this judge made a mistake. This judge understands that mistake was made and tries to justify it somehow, tries to correct it somehow, that maybe the workload was so high, or maybe some other objective factors. For example, there was a heavy disease or anything else. But another judge could try to do it in another way. They try not to admit that the mistake was made, even despite of the fact that there are no objective reasons for that. So this judicial self-governance, judicial unity, of course, are based on judicial ethics. So the judicial ethics is an element of judicial self-governance. I can't imagine a situation when judicial self-governance is based on non-ethical norms for judges. I think it's unclear. It's not acceptable either for me, not for society. I think that major part of judges are decent ones, are good ones, but sometimes they make mistakes which maybe could be avoided. Actually, in reality, major part of mistakes made by judges, and as we mentioned in the document, that very often such mistakes are, are made by human factor, caused by human factor. For example, a judge didn't have enough time to consider the case, didn't call a witness to come, didn't interview someone. Of course, such cases could be, and of course, we cannot leave them without response, but disciplining them should not be so high and should be appropriate.
Last question is this. You have a long and very colorful legal career. And I would like to hear from you about one situation which you consider to be of the character of ethical dilemma, or if you would recall this situation as a very tough one for you to resolve and to proceed in that situation. If you can describe the situation and then tell us what did you do with it.
Ну, от, зокрема,
That issue That question that I was asked by a colleague was I had a practice to submit disciplinary complaints to the HCJ. Actually, before that case in 2017, I even hadn't known about such possibility. Of course, as a lawyer, I had known that yes, there is such a potential option to submit such complaint, but I had not used such a tool before 2017. I didn't plan to use it in my practice. To my opinion, if there is a possibility, each decision could be challenged. If not, you shall look for other options as a lawyer, as an attorney. You always could suggest the strategy for a client which will comply with the law and also will benefit this client, either for protection of their property rights or for their financial rights. And that situation, I recall that I didn't want that much to submit that complaint, but the client insisted. We lost time and money, and the most important that there was no solution for that issue in the legal sector, in the legal sphere, because as far as I remember, that ruling was not possible to be challenged. It was a final decision, and of course the client was so disappointed. They needed to submit that complaint and to submit the complaint to the HCJ. And as far as I understand, the disciplinary chamber made such a half decision that yes, they indicated there were all grounds for disciplining the judge, but the judge was on sick leave. I think she broke her arm and so on. That's why they decided not to discipline her. So at that time, because the client insisted, I submitted that complaint and I got the decision which the situation was described, but actually the judge was not disciplined. For me, it was some kind of ethical dilemma, but at that situation, the demand of the client was the key one.
A dilemmatic situation for you. Why exactly?
Я пам'ятаю, просто було засідання.
I remember that session, and the judge mentioned that my arm is broken. I'm near her, and yes, I realized that indeed, if I realized that her situation was like this, maybe I convinced the client not to challenge that decision, not to submit a complaint. Yes, it was so not a pretty situation, but the situation took place.
Thank you.
Так, можна?
So let's proceed to the second part, or you would like to ask the question regarding professional competence? Okay.
Якщо можна,
If I may, in your motivation letter, you mentioned that at future you plan to involve disciplinary inspector's assistants to work with complaints. What did you mean? And what are these positions? Who are they? Those inspector's assistants? Who are they? Would they belong to the civil service or support service? And why do we need it? Yeah, I will explain it to you. No, not civil servants. Definitely not. I didn't plan to extend the staffing or to submit proposals regarding salaries and so on, but in some previous time I worked under guidance of the HJ member, Mr. Miroshnichenko. He had introduced such practice for internship for students of the third and fourth grades of university who had already some knowledge, but they needed this internship for development of their legal career. And I think that as a disciplinary inspector assistant or as a HCJ member assistant, such person has relevant authorities how to identify information. So those students had a possibility to have internship, and they worked as full-fledged assistants to the HCJ members. They drafted some decisions. As a role of the inspector, I helped them. I showed what are the drawbacks of their documents, what they need to improve, what they need to maybe to learn more. Some of them reached significant achievements. Some of them continued their legal career. Okay, thank you. All is clear. So that's some kind of internship for students. Yeah, definitely, like this.
Okay.
Mr. Alexander, I have several questions. Let's come back to your explanations that you've provided, and with respect to which you've been asked several questions in writing. In your written explanations, you said that while working in the HCJ, you worked remotely, yes? Yes. And from time to time, you came to work. According to the determined schedule and duty to, you were not obliged to come every day to your workplace. But according to the instruction of the HCJ, the remote mode of work was suggested from March 17 of 2020 due to the quarantine. In connection with this, I have a question. In the declaration for 2019, you specify the place of residence in the apartment that you have under the right of ownership in Umань. In 2019, the remote mode of work did not exist in the HCJ, right? Can you please tell me where did you live and why, in this case, you did not specify in your declaration for 2019 the right to use residential premises? Yes, thank you for your question. Since I worked in 2019 in the HCJ for 3.5 months, out of which, 4 months. As far as I remember, the legislation that was valid back then, it was necessary to declare housing that you have under right of ownership or use as of the moment of submission, as of December 31st of the reporting period. Right now, the legislation envisions that it is necessary to declare those right to use or right of ownership for the premises that last for more than 183 days, if I'm not mistaken, because I'm not the specialist in declarations, but that's what I remember. Since I lived in Kiev for 4 months maximum, then of course as of December 31st I was not in Kiev. I think I resigned on March 27, so probably there were no grounds to declare that. Okay, my next question is, sorry, maybe I misunderstand something, but I would like to clarify. In the HCJ, you worked from 2017 and you resigned in 2021. No, sorry for interrupting you, but no. Okay, I'm asking you about 2019. In 2019, there was no remote work, and you are saying that you worked for about 4 months in 2019, yes? Absolutely correct. Maybe you have some incomplete information. Then tell me, please. Okay. The matter is that on April 28 of 2019, I was dismissed from the position of the inspector since the term of powers of Mirochenko as the HCJ member expired. There were no suggestions for me to continue my work, so on the last day of his term, I was dismissed. I left the premises of the HCJ. Okay. Can you please tell me, in your explanations, you also stated that during the period of your work, you almost did not communicate with the HCJ member, but you were delegated to the specific member of the HCJ as the inspector. How could you perform your work in this case? How did you consider and prepare complaints? How was your work organized? Okay, thank you. Again, while working with the specific HCJ member, I will not name the surname, but I understand the answer to your question. Okay, we had this remote mode of work. We were prohibited in the HCJ to be for a long period of time. I remember I was asked and I was said no. The remote mode of work envisions the work from home, basically, unless and with documents on your official laptop. So communication with the HCJ member during could happen probably only in the form of reporting. So we were preparing draft decisions. We were transferring them through the secretary. There was a secretary, an assistant. We had a group. I think it was called Office and the surname of the HCJ member, and we uploaded draft decisions there. We had the practice that your draft decisions were assessed not by the HCJ member, but another inspector. So we had this sort of cross assessment, and the other inspector provided some instructions, suggestions. Sometimes I disagreed, sometimes I agreed, but usually it was teamwork. Sometimes two assistants and two inspectors were working on one decision altogether. If the decision was approved, and that was mandatory for the other inspector to approve this draft decision, then we sent these draft decisions for printing, and then they were transferred to the HCJ member, and he either approved them or disapproved them. Like, there was not option to agree on the text of the draft decision. I remember if the draft decision was approved, then it means that you performed your work in a good way. If no, then you had to rewrite it. Can you please clarify then how did you get tasks? How did you get materials to process them? How in the HCJ physically and took them and brought them, if we are talking about paper documents, but if we are talking about the distribution of cases among inspectors, I do not know about the principle, but as far as I understand, they tried to equally distribute these complaints so that each of us had simple and complicated complaints. I think it was a huge table there, and it was specified there, for example, 200 proceedings under specific ECJ member. Then it was stated this is for Krotenko, this is for some other inspectors, that's for someone else. And in this Excel sheet, you could see, for example, the number of decisions prepared by each of the inspectors. I had the highest number of remaining cases because I was sick after COVID. I had difficult times. So at some point, I had accumulated unresolved complaints. So other assistants helped me. They took some of the complicated complaints and helped me because at some point I had over 100 of them and I managed to finish them by the end of the term. Okay. This mode of work was introduced for all assistants and secretaries of the HCJ because as far as I know, assistants came to work. Yes, I came, but not often. Not often. I was directly prohibited. I was said that you cannot come to work every day. I asked this question why, and I was told that's remote work. You have to work remotely. You have to perform work on drafting decisions and not come into the workplace. That's it. And how often did you come to the workplace? As a rule, it was upon request, maybe twice per month, but not more often than that. You came, took documents, and processed them at home. Yes. Okay, thank you. I have one more question to you. In the declaration for 2016, you mention corporate rights in LLC partner China, and the monetary value is 63,000 hryvnias. Yes, yes. And later on in 2017, you sell them for 200 hryvnias. And your explanations, you say that no, this LLC had no value, and the value of the share was determined based on the expense of time for registration of these documents. So how did you determine this 63,000 as the value of this LLC? As of the moment of establishment of the LLC, if I'm not mistaken, or not soon later on after the minimum charter capital was quashed, it was a requirement to have 100 subsistence minimums, so that's how we determined this amount of the charter authorized capital. It was not formed. If I remember correctly, back then partially this enterprise did not have funds or property. It was just established, just like all LLCs as established. But there was no responsibility for failure to make contributions for the shareholders of this LLC. Yes, according to the register, the authorized capital was 63,000 hryvnias, but actually it had no value as such. Okay, thank you. I have no more questions about this.
So our interview is coming to the end. It's already more than 1 hour. So if you have some final comments, you can take the floor and take 2 minutes to comment. Thank you.
Thank you. Thank you, Ms. Chair. Thank you, dear members of the Commission. I would like to express my gratitude again to you for this opportunity to talk to you, regardless of the result of this competition, in particular for me. The role of the SDI that will be established in the near future will mean that judges and lawyers will understand which guidelines they will use in their practice. While talking with other lawyers, attorneys, I hear only positive feedback that the service of disciplinary inspectors should be created. And especially it was pleasant to hear from my colleagues that they are saying, like, this candidate won in the competition. And it's so strange for people that a person submitted documents, passed all the stages, and really the society, the professional community recognize these results. They perceive them and they believe that this is only for the better, that the specific person, the specific candidate, or the entire service will be able to ensure proper consideration of disciplinary complaints, because this problem is long in Ukraine. Thank you.
For participation in the competition and sharing your insights. And our decision will be announced on Wednesday on the winners. So wish you the best of luck. Thank you.
Thank you. Thank you.
Добрий день, good afternoon, Pan Taras Mironovich Kuzik. So this late afternoon we will have interview with one more candidate for the position of the head of disciplinary inspector service. First of all, I would like you to introduce to our commission. Today we are in our entire composition of the commission. I am Reda Molene, the chair of the commission, and the commission members are as follows: Yulia Bokova, Olena Kovby, Olga Popikova, John Ehrlich, and Pavel Zelinchik. So our interview will last approximately 1 hour. It may be extended for 10 minutes or so if needed. And first of all, we will ask some questions about your professional competence, skills, and managerial competences. And later we will have this session on integrity. Before our sessions of question, you will have up to 10 minutes for your presentation of your vision, your understanding of the role of the head. And at the end of the interview, you will have several minutes for your final comments. And also, I would like to inform you that the interview is broadcasted. Probably you know already, but just for you to know that if you have any information that falls under restrictions for its public disclosure according to the martial law, please inform the commission at any time of our interview, and we will take a decision accordingly. So before starting, would you have any requests regarding our composition of the commission or any other requests? No requests. So then we can proceed with your introductory presentation, and the floor is yours, please.
Дякую.
Thank you. Good afternoon, dear Commission members. I'm grateful to you for having the opportunity to be here and take part in this competition, and I would like to share my vision of the work of the Service of Disciplinary Inspectors. And can we please put on my presentation on the screen? So, vision and action plan of the Service of Disciplinary Inspectors. First of all, I would like to share with you my experience that I've obtained while working in the Kyiv District Administrative Court at different positions, including managerial positions as well. For the past 11 years, I have worked as the Deputy Chief of Staff of the court in a quite large court. With the decree of the President of Ukraine, upon recommendation of the High Council of Justice, the Chief of Staff of this court was appointed as a judge of Kyiv region, and since then I have performed duties of the Chief of Staff. That's for about 4 months now. As I have mentioned, our court is quite large. The court apparatus has 147 employees. What experience have I gained over the period of time of my employment, and which can be useful for me if I win in this competition? In this respect, I would like to say the following. We have faced a huge number of difficulties in our work. However, one of the key moments was adoption of the resolution by the Parliament on liquidation of the Kyiv District Administrative Court. On one day, the court was liquidated, and all of the cases which were not considered by that court, and that was about 46,000 cases and materials of cases, as well as cases which were in their possession, that is about 250,000 cases, had to be transferred to our court within 10 days. That was an extremely large number of cases, given that the dissolved court was twice as big as ours. In our court back then, we had about 22 sitting judges. So, at the start of this situation, we created the commission on acceptance of the cases from the dissolved court. On our side, I was head of the commission, and we started transferring this huge number of cases to us processing them, register them in the workflow system, and to transfer them for consideration to our sitting judges. Until July of this year, that is for a year and a half, our court managed to accept all 60,000 of cases, but we processed and allocated among our judges 40,000 cases, and now our judges are considering these cases. As far as I know, that the High Council of Justice, maybe I have some inaccurate information, but as far as I understand, there will be about 5,000 complaints that have to be transferred for consideration to the SDI and allocated among new inspectors. I believe that my previous experience, will make a valuable contribution to this work. After the creation of the SDI, inspectors, the head and deputy head of the service, in my opinion, will face the following challenges. The first biggest problem is that 25 inspectors and the head, who previously not always participated in consideration of disciplinary complaints. Maybe not all of them even had experience of working in the courts or filing complaints with the HCJ. And after some period of time, they will receive 5,000 disciplinary complaints, which is basically, for specialized lawyers, will be quite a complicated task. It is also necessary to take into account that every month after the start of procedural activities, there will be, maybe I have some inaccurate information, but I think that we will receive about 350, 400 of new disciplinary complaints, which will be submitted, which will be allocated among inspectors of the SDI. So we have to take that into account. There are 5,000 of unresolved complaints plus new complaints to be received. So I suggest, and as I see it, the following plans in the functioning of the service once all the employees are appointed. So during the first week, it is necessary to get acquainted with each other, with the head and the deputy head should get acquainted with the inspectors, and maybe they should get acquainted with the head of the secretariat of the HCJ as well, since the head of the secretariat is their supervisor as well. It is also necessary to organize training and team building, because all 25 inspectors and the head probably will not know each other. So I think that training and team building are necessary. First of all, it should be either at the basis of the National School of Judges, maybe on the basis of the High Council of Justice, since in any case, training has to be conducted. Also, in the SDI, they will have their own workflow system, the database, some computer software, with which I personally, and I'm sure the majority of disciplinary inspectors, have never worked before. So in any case, it is necessary for responsible employees teach new disciplinary inspectors and the head and the deputy head on how to properly enter information and how to process it. So some time is needed for that anyway. It can't all be done in one day. So then, of not only disciplinary inspectors, but also of those people, documentation support unit, which will deal with incoming and outgoing correspondence. So it means that they will work with the ISITS program, they will register new complaints, they will receive those unaddressed complaints from the HCJ, they will also send outgoing correspondence, so those disciplinary complaints that will be received into the unified system. Of course, final decisions will be sent automatically to complainants in this unified information system. But there will be also some paper-based complaints. So this unit will be responsible for the outgoing correspondence as well.
So the next is analytical and statistical department. It will deal with analysis of the practice of consideration of different categories of disciplinary complaints, and also it will take into consideration the withdrawn, non-satisfied, or returned for improvements, conclusions or draft decisions, and will provide some documents for meetings of the head of the service with inspectors in terms of statistics and the category of complaints which contains some inaccurate data. Then operational support for the head of the service. What this unit shall be comprised of. So first of all, I think that this unit shall provide draft replies both for inquiries and requests of different citizens, attorneys, private and legal entities who can reach out to the Commission asking to provide information regarding complaints, whether a complaint has been considered or not, what is the deadline, and so on. So in order to not to add this additional work to discipline inspectors to provide such additional information, because there are 5,000 of complaints which are yet not processed, not actioned. So there will be a huge number of requests regarding such complaints. So I think that such unit should be also established. So 1 month of functioning of service. So 1 month, that's when already trainings have been passed, units have been established. It means that we will need to start preparing the service of discipline inspectors for the commencement of their procedural activities. Just to underline that 1 month, that's not a month of procedural activities. No, that's months when, since the moment that it's established. So we have premises at the Tarasevska Street. Of course, it's clear that the condition of that premises is not compliant with requirements. We need to prepare, refurbish, deploy all local networks, install networks, and install all relevant working place for discipline inspectors. For discipline inspectors to know that they come to their office, to their workplace, and even if there is a blackout and there is no electricity, they will be able to work. Also, in order to arrange our operations, is just to have joint meetings with them. With the representatives of the apparatus of the court and discipline inspectors. And the last thing, which is the key problem that we need to overcome, that's to find employees for the support service, for the apparatus of the service of discipline inspectors. And actually everything depends on the level of salaries. I'm sure if the salaries are decent, quite high, we will be able to find very quickly such employees, and I'm sure that also some of the HCJ employees would like to apply for those positions. 2 months. I think that the 2 months is the period when actually the service should start, should commence its activities. So first of all, we need to cover the logistical issues. Logistical issues with the High Council of Justice, so communication with the head of the service and the head of the secretariat. They should agree how to correctly transfer this high number of complaints from the HCJ to the service. Then we need to register them in a correct manner and distribute them among discipline inspectors. Yeah, of course, it's clear that maybe it's impossible to handle such distribution for 1 day. I don't know what is the software will be available for the service. If those databases are somehow connected, then maybe we will be able to register those complaints based on information available for the HCJ, and of course it will require less timing from our side. But if this information requires additional efforts from our side to fill in some additional pieces of information, then we will need, of course, much more time in order to register all 5,000 of complaints. 6 months. As far as I can see the situation, I think that one discipline inspector will be able to consider at roughly 2 complaints per day. If it's so, then during a month, 50 complaints should be considered per each disciplinary inspector per 1 month. Of course, I understand that it's not, the highest threshold. Someone could consider 60, others could consider 40 complaints per month. Complaints could be different, easier, more difficult, and so on. But generally, I understand that 50 complaints per month is quite a feasible figure for one discipline inspector. It means that within 6 months, this service could reach the level of considering 5,000 of complaints. Of course, it's clear. So 5,000 of complaints. Of course, it's clear that that maybe it will not be only those complaints which are right now under registration of the HTJ, because different complaints have different level of complexity. And such number of complaints which will be transferred and registered each month at the service, it will cause the following fact, that I think that in 1 year from the beginning of the commencement of the activities of the service should reach the level when the service will work only with those complaints which would come to the service and be registered during that period. So with those complaints which come during a month or two. So I think that is objective deadlines in a year to achieve this threshold. So I think that for the only way to achieve results is through experience, a clear goal, and a desire to succeed. Thank you so much for your attention. I'm ready to answer your questions.
And if colleagues, you would allow, I would ask the first follow-up question. You mentioned and you put in the structure that you already drafted as you envisage the possible structure of the service. On the top, you put the head of the Secretariat of the HCJ. However, you emphasize that this is the service is autonomous body. So my question would be how you see the powers of the head of the Secretariat of the High Council of Justice towards this newly established institution. What are the powers, according to your opinion? And as we have a requirement for the candidates to the position of the head of the service to possess the knowledge of foreign language, and your foreign language is English, as we know from material. So could you please respond in English? Thank you.
The head of Secretary High Court Justice must be only participate entertainment with head of service of disciplinary inspectors, only like I'm sorry.
Could you please then answer in Ukrainian, just to give the answer to this question,
Okay.
please? Thank you.
На моє переконання, служба
So to my belief, the service of discipline inspectors that's stand aside and autonomous unit, but at the same time, it's under the system and organizational umbrella of the High Council of Justice. As the head of the High Council of Justice is the head of the Secretariat of the HTJ and the head of the SDI, and his or her role is the deputy head of the Secretariat of the HTJ. I think that any actions that should be done more in organizational nature, financial, maybe material nature, maybe also in the dimension of the human resources, the head of the SDI should agree those actions or should get an approval regarding such actions from the head of the Secretariat of the HTJ. But the head of the Secretariat of the HTJ should not influence in no way on the service of discipline inspectors and discipline inspectors generally.
Give the floor to Commission Member Olga Popikova to start our session of questions, and maybe we will come back to the question on responding in English a bit later after warming up during the interview. Thank you.
Greetings, dear Taras Mironovich. You have this understanding of the workload that will be expected from the service of discipline inspectors, the challenges which the SDI faces. But tell me, please, what about your personal motivation to participate in this competition and lead the newly established service? Thank you for your question. I will start from the following. That I have been working in the judiciary system for more than 13 years. And maybe that's not the first time when I plan to change my place of work. But before that, I didn't dare it, only because there were some other accompanying problems. Such there was a period of the COVID pandemic, there was a period of the beginning of the full-scale war with Russia, when Russia entered its forces on the territory of Ukraine. Also, I have a young family. My first child, second child were born. Changing of place of work always, these were limitations for me. So earlier, I maybe made a decision in 2018 that I need to go to I need to apply for the bar sector, for the advocateship. So I prepared documents, I applied for that position, but then I didn't finalize it. And as far as I found out that as a civil servant, I have no right to actually apply for the bar certificate, and that's why I decided not to start working in that sector. In 2018, my child was born, then my daughter was born, then the pandemic times, and the full-scale war. Sorry for answering for so long time, but now I'm answering exactly for your question. So I followed the amendments into legislation, and I followed the news regarding the service, specifically regarding this competition for this service. And I remember that the requirements, even for the position of discipline inspector, were higher than I could comply with. But then amendments were made to legislation, and the requirements to candidates were decreased. And I applied for the position of discipline inspector. And then, generally, then I applied for the position of the head when it was already clear that there is a new competition for the head of the service. I think that I have quite an interesting experience on the managerial position. Definitely, it will be valued, and definitely it will be in use. It will be of help for the new service. Maybe I regret a little bit that I didn't pass for the position of a discipline inspector, but it actually allowed me to apply for the position of the head. Because maybe if I had succeeded for the position of discipline inspector, I would not have applied for the position of the head. Okay, clear. Thank you. So, your huge experience at the judiciary system, and at one place you have been working actually for 12 years. No, for the last. So I mean, as a position of the deputy head of the secretariat for more than actually 11 years I have been working there. Okay, clear. Thank you. Tell me, please, how many persons do you have under your subordination? Is the apparatus a big one? Yes, that's a big. So a part of judges, 147 persons are in the staffing list on the apparatus of the court. We have a huge number of vacant positions right now, but it's, as in any other court, specifically of the first instance. So maybe for now, around 100 persons are under my subordination. Okay, tell me, please. Everyone knows that the issue of deficit of financial support for different apparatus of courts, it's a problem. And it's better than anyone else. But you are not responsible. It's clear. It's clear that you're not responsible for the funding of such apparatus. But at the same time, you're the deputy head, and now you're acting head. And how you motivate your employees? Because I think that in any case, such experience could be of usage for you if you gain this position of the head of the service. Because yeah, you know, the procedure is quite difficult, quite complicated of selection of inspectors, and we are, as the HCJ, of course, expect that inspectors are going to work, the service is going to work and function. How do you motivate your employees? You know, I think we have very good atmosphere at our court. Our team is young, all of our employees are young, and as all of us, we effectively work in Kiev. We have a turnover of employees around at the level of 30% per year. Also, our funding of our apparatus was significantly improved since August this year. That's the first category. The first category. Yeah. But anyway, in Kiev, the level of salary should correspond to the lifestyle, the level of life at Kiev. You know, the court of the first instance in Kiev and the court of the first instance in Ivano-Frankivsk, they can't be the same in terms of payments. How we motivate? We allow our students to come and work at courts. So each student who comes for internship at our court, at the end of their internship period, we ask them, would you like to work at us? And actually quite lots of students indeed keep working at our court. So they work, for example, the position of secretary and the chancellor office. And for them, it's a very good CV line because, yeah, they could gain this experience and then further go for the bars sector. Okay, thank you. Indeed, that's a valuable experience. But how do you solve conflict situations? Because yes, your team is quite a big one. Do you mean conflict situations between whom? Between employees or parties? No. Not between parties. It's not very related. Let's deal with employees. So, okay, conflict situations between employees. I can't tell you that we have any conflict situations, but the team is big. Yeah, the team is big indeed. But anyway, so there are different groups, we have different chancellors, subunits, different secretariats. All of us are more or less of the same age, all of us are friends, and yeah, we have a group of older employees, but there are only a few of them, up to 5, not more. And young employees, they have other vision on their work, they just love working beyond working hours, even more than during working hours. They have better working capacity after working hours. For example, for me, I work better in the morning rather than in the evening. Speaking regarding conflict situations, we didn't have such situations to intervene for our leadership. Okay, thank you. That's a good example. But tell me, please, that the head of the service is going to carry out assessments and assess actually the performance of discipline inspectors. Do you have any relevant experience on that matter? Yes, of course, I am. As the acting head of the apparatus of the court, I also carry out verification and assessment of performance of all employees at the Kyiv district administrative court. Thank you. And another question, which is still a pending one. As for now, it's not clearly defined that the head of the service is a disciplinary inspector. What do you think on that matter? Should the head of disciplinary inspector perform also the work and workload of a disciplinary inspector? I think that he or she not only should, but it's obligatory for a head to perform this role, because going back to the previous question, so the head should review the performance and the work results of disciplinary inspectors on the service general. In order to do it correctly, he or she should consider by themselves different disciplinary complaints, and I'm sure it will be covered by the regulation on the service. I think here we should follow also the law on the judiciary and the status of judges, and in order to decrease the workload for the head and deputy head, because they are going to fulfill their administrative duties, which also will be quite huge ones, especially in the beginning. And additionally, not from the beginning. We need to add this workload for the head to consider different disciplinary complaints. Maybe first 2-3 months, he or she will need to arrange all the things and to arrange the functioning of the service and then to be engaged. But I believe that it would be fair for the head to consider disciplinary complaints from the very beginning of the functioning of the service.
We can make some parallel with presidents of courts who have some coefficients. Okay, thank you. And tell me, please, how do you see cooperation, interaction with members of disciplinary chambers? I mean, interaction between inspectors and members of disciplinary chambers for proper preparation of disciplinary cases and respective draft decisions and rulings. In my opinion, since this is autonomous structural unit, the service, interaction regarding proper preparation. Preparation. There are two visions. The first vision is that some disciplinary inspectors can be delegated to some disciplinary chambers. Here we have such an advantage that is, firstly, some disciplinary chambers will organize their work and their meetings on specific days. So since, for example, Tuesday and Thursday are the days for plenary sessions of the ACJ, and for example, the first chamber, I don't know, for example, let's imagine the first chamber will work on Mondays, then it will be comfortable for the disciplinary inspector who is delegated to this disciplinary chamber, number one, to prepare all of his or her draft decisions and to be ready on every Monday to go and prepare draft opinions and defend them on Mondays. Because if they go to different disciplinary chambers, it can happen that they will spend more time in the ACJ than at their workplace. And basically, they will have no time to prepare new materials. They will have to be all the time in the ACJ defending their draft opinions in front of disciplinary chambers. So you support the idea that disciplinary inspectors should be delegated to a specific disciplinary chamber. But there are some risks, yes, of course. We can't ignore them because logistically and effectively, I agree with you that. But how can we avoid this risk for the future in order to have that the inspector is working with this chamber and that's it? I think that at the beginning of procedural activities, we should not delegate these inspectors to disciplinary chambers in order to make sure that external observers have no doubts about objectivity. The service should start from a clean start and work perfectly since the very beginning. If in the future it happens, like I mentioned in my first response, then yes, maybe we will have to revise that. Or maybe sometime later they can be rotated. Okay, and my last question, if my colleagues allow me, can you please tell me? Can you please share your vision? Which measures maybe should be introduced or considered in order to ensure compliance with prioritization and terms for consideration of disciplinary complaints, because that will be also one of the very topical issues. Yes, that's for sure, especially during the first initial period of consideration, when the disciplinary inspectors start receiving disciplinary complaints in huge numbers. Since the very first day, they have to systematize somehow their work. In this respect, it is necessary to conduct training for them since the very beginning, to tell them about methods and means and how they can build their work. For example, there is a method of green, yellow, red. So once you understand that you can quickly classify by months, and then you work with the last month. So first of all, then greens can be returned, left without considerations. Then yellows are submitted for the disciplinary chambers. Red means that you have to collect documents and start working with them. Of course, it's necessary initially to have a result green, yellow should be worked first of all, and then with red we need to wait until you get all the responses to all the requests that you've sent. Then you have to move on to the next month, and that's it, by going step by step. However, in the rules of procedure of the HCJ, there are some categories of disciplinary cases which require immediate consideration, like without waiting, without delay. For example, this is if there is a high public interest in the case, if there are signs of a disciplinary offense which can entail disciplinary responsibility in the form of dismissal of a judge, and then that is also if a judge, if the qualification evaluation is suspended until the end of consideration of the complaint. So which measures can be undertaken in order to ensure compliance with this prioritization and terms? Prioritization has to be first of all based on the moment once the complaint is received. You have this moment of receiving the complaint, then you have to understand with respect to priorities. Initially you have to consider priority complaints, then all the priority ones, I'm sure that they will be considered outside of the terms because they require to collect a lot of documents. So accordingly, you start with working with red, that is priority and complicated cases. You launch work, you send requests, you wait for responses. While you are waiting for responses, you are considering yellow, green ones in order to have results and then to avoid accumulation of complaints. Okay, thank you. Colleagues, I will not abuse my rights and will take too much time. So please. Taras Maranovich, good afternoon. Good afternoon. I have several questions to you. And my first question is about you telling about your huge experience of working in the administrative court. You told us about your huge experience of accepting cases from the liquidated Kiev Administrative District Court. You are aware of the number of disciplinary complaints in the ACJ, and you've told us about the period of time approximately during which you as the head can organize consideration of these cases. This is statistical information, so that's statistics. Can you please tell us what is important in your opinion, speed or quality? Of course, both. Both quantitative and qualitative indicators are important. In order to have qualitative indicators, the SDA has to work for some time. Because since the very first day, I'm sure that qualitative indicators cannot be achieved at once. I'm sure that everyone who comes to the SDI and who will become the disciplinary inspector will feel like disciplinary inspectors after a year of the start of procedural activities. Once they develop the experience, once they gain it, once they have some statistics inside the service, once problematic issues are discussed as to why disciplinary chambers quash decisions, how to improve quantitative indicators, with a breakdown by each disciplinary inspector. It is necessary to work on this. And briefly answering your question, basically I support quality more. Okay, a year is too much. Quality has to be ensured earlier. Can you please tell me what steps for improvement of quality can be suggested by you? For example, you have new disciplinary inspectors coming to the service. All of them come from different sectors. Some of them academic, some of them lawyers, some of them are court employees. How would you ensure organization of effective and quality consideration of disciplinary complaints? Not only quick, but also the quality one. Okay, thank you. As I have mentioned since the very beginning, it is necessary to organize training. It is necessary to train each disciplinary inspector at least with what they have to do at the very beginning. Of course, all the inspectors that will come to the service have knowledge in the sphere of law. They just have to be partially instructed during training, team building, on how to focus attention on some peculiarities related to the consideration of the disciplinary complaints by the ACJ. It should be done on the basis of the School of Judges or maybe HCJ once they tell about their methodology, their statistics, their analysis. And that's at the very beginning. Then, once the service starts working on a weekly basis, the statistical unit will show. Here we have these results. Of course, during the first month, maybe we'll have no objective statistics, but then with each coming month, we will have some vision with respect to some category of cases, which is considered quickly, which is considered in a more correct way. For example, every week we will hold operational meetings together with employees, together with disciplinary inspectors, and then we can emphasize. Hence, in the service, we have this number of disciplinary materials sent to the disciplinary chamber. Out of them, 95% have been approved. We have shortcomings in 5% of cases. These are the following categories. Here, our vision is the following. Here, disciplinary chambers see it as follows. So we should pay more attention to the vision of the disciplinary chamber so that in the future we can decrease the number or increase our qualitative indicators. Okay, thank you. What do you think about another opinion of your colleague, if it does not coincide with your opinion? Can you step away from your opinion? Or maybe you can find some compromise? Look, each argument is very important because during arguments, truth is born. I'm recollecting myself when I was younger and when I was working in the other positions. I was always arguing, not arguing, but I was always talking with my management, and I tried to prove and convince them of my positions, my opinions. I was providing some examples. Of course, in the majority of cases, my opinions and my positions were not correct because I had less experience. Once you have an argument, I mean in the meaning of not a conflict situation, but like how to properly act, then of course you need to listen to the idea of your interlocutor. You have to provide your own explanation, maybe make a pause for a day or two for each of you to provide materials to confirm your opinion, and then you can come back, and I'm sure that you can find some common ground and take a correct decision together. Are you sure about that? I hope that it will happen like that all the time. Thank you. I have no other questions. Good afternoon, Mr. Taran. Good afternoon. I have some questions to you. Can you please tell me how did you share your duties with the Chief of Staff? What were your duties and obligations? What were you doing as the Deputy Chief of Staff? Thank you for your question. I will come back to 2011. I started working at the position of the court hearing secretary, but basically I was performing duties of the court secretary in the workflow unit. After that, for half a year, I worked in this workflow unit. I worked on the position where the employee was on the maternity leave. And then I was transferred to the position of the court clerk, but I continued working in this unit actually. A year passed. After that, I was appointed to the position. I completed internship. We had high turnover in the staff, and I was suggested to undergo internship for the position of the deputy head of the unit. That was my first experience at the managerial position. At this position, I worked for about a year, I guess. And so going back to your question about my duties. Since early 2011 and until nowadays, my key duties include organization and control over the workflow units. That is one of the key functions that I have. Then that's interesting. Since the start of the full-scale invasion of Russia, unfortunately, in our court apparatus, we did not have any employees in the IT department. So we had no IT administrators, and these functions were delegated to me. And for 2.5 years, I had to learn how to work with servers, computers. These are additional functions. Besides, I was the head of the selection commission on hiring new employees into the court. And I was also the member of different commissions for work in the court. So my key work has been organization and control of work of the workflow unit. Okay, thank you. This experience that you have, in your opinion, can it help you in case you are appointed to the position of the head of the SDI? And do you see some similarity between the duties that you are performing right now and between duties that you will be performing in case you are appointed to this position as the head of the SDI? Actually, I see similarities. And I have emphasized in my presentation that it is important to organize the workplace of each disciplinary inspector. So it is necessary during a short period of time to find a person who knows how to work with servers and network. And it is very difficult to do that nowadays because those specialists that we have on the market want high salaries. My experience at the level of amateur at least helped me to understand how it should work. Basically, I understand how it should work, but maybe I will be able to somehow resolve some problem quickly. Besides the start of the work of the SDI, will be performed by the workflow unit. They will have to accept 5,000 complaints. They have to register them and to distribute them among disciplinary inspectors together with a report on automated distribution. So I understand how that works perfectly well. Okay, thank you. Can you please tell me, as you have mentioned, as we all know, all the cases from the liquidated District Administrative Court of Kiev have been transferred to your court, Kiev District Administrative Court. So, in your opinion, why that court was liquidated? Why that situation happened? Your personal opinion. Probably my opinions are the same as everyone has. That was preceded by repeated systematic problems with corruption and influence of and abuse of their powers by judges of that court. As far as I know, maybe there are more than 5 criminal proceedings that are considered with respect to those judges in the High Anti-Corruption Court. There are many disciplinary complaints which are considered in the High Council of Justice. Also, as far as I know, that is probably the only court against the president of which were imposed personal sanctions of the US. So accordingly, a week before the liquidation of the court, the US imposed personal sanctions on the president of that court, and probably it became the final straw for the draft law that was submitted by the president, if I'm not mistaken, that was registered with the parliament for a year, was not submitted for voting by deputies. And only once personal sanctions were imposed on the president of that court, then the parliament adopted the law through first and second reading. And in a day or two, the court was liquidated. Okay, thank you. And one more question. You are from the judiciary, you work in the court of Kiev. If it is decided that the head of the SDI performs the function of the disciplinary inspector and you are appointed as the head, what will you do if you receive a disciplinary complaint against a judge of your court? Okay, thank you. I'm sure that if everything goes well and I win this competition, I will receive complaints against judges of my court. In this case, again, it is necessary to check the regulation on the SDI, and I'm sure that it is necessary to resolve there the issue regarding recusal and self-recusal, so that each disciplinary inspector, including the head, could recuse themselves, or so that recusal against this person could be requested, so that external observers would have no doubts about objectivity. Because right now, as far as I understand, there are no clear regulations regarding recusal, self-recusal, but even if the regulation on SDI does not stipulate this, still I, as the head, would apply other procedural legislation. I would use analogy with civil and criminal procedural legislation, and I would recuse myself, because it is still would be better than me considering the case, the complaint against the judge with whom I worked before. Okay, thank you. And my last question to you. How can you explain quite insignificant score that you received during the first competition for the position of the disciplinary inspector? Thank you for your question.
Тут
Objectively speaking, at that period, it was the end of June, beginning of July 2024, if I'm not mistaken, and there was the following situation. As you can see from my presentation, I mentioned that we received more than 60,000 of cases, but only 40,000 were successfully registered. It means that the Commission has been established at that time on development of the regulation on redistribution of those 20,000 of cases. De facto, we registered them, but it would have taken much more time than the Verkhovna Rada. So there was already a draft law registered there on redistribution of that part of cases which we need to handle, so to redistribute them among other courts across Ukraine. So I was a member of that group together with representatives of different information and court systems. There were also representatives of the Supreme Court. We discussed what should be included, what should be the procedure of redistribution of those 20,000 of cases among other courts. At that time, I didn't have enough time to prepare myself correctly and adequately to the written part, to the written stage of the competition. But at that stage already, at that competition already, I took an annual leave. I prepared myself, and I think that I showed quite a good result. And also, to complete my answer, this Friday, we have redistributed 20,000 of cases among all district courts of Ukraine. Now we need only to transfer them to those courts. Thank you.
Thank you. From your previous current experience that you describe and tell us about the team that you are working with, the administration of, that it is very efficient, effective, people are working as a team, really. And also, you have this vision, as I see from your motivation letter, I quote, "As the head of the service, I will be not only a manager, but also a leader who will assist in rapid launch of activities and will empower employees, and this will help them to fulfill their duties in the shortest possible time." This empowerment of the employees. So you have an experience making the team efficient. What are your tips and tricks as a leader to make the team working efficiently? And I'm not now talking about raising competence of people that you already described, that initial training and ongoing trainings is very important. But as a leader, as a facilitator of a team, what are your tips and tricks? Could you please share with us?
Tips and tricks, you know, there are no specific tips and tricks. Here, we need to understand this difference between the leader and subordinates. For subordinates not to cross this border, and for you not to go down to some lower some threshold. I think that I should have friendly relationships with subordinates, but not to cross the line. At any situation, I try to explain how it should be, to show by my own example, based on my own experience, to share my story, my previous examples from my personal life, from my previous working experience, from any and I do it with any employee, from the secretary to any other employee. And also you should be in constant communication, constant touch with your employees. If you are at your working place, if you see how they work, you know where you have advantages, where you have drawbacks, where you have some drawbacks, some problems, you need to pay more attention. Where you have some advantages, you need to say how it's good, how they are cool, what they've done, what they do in a cool manner, for them to maintain this level of motivation. Maybe also to combine the composition of different teams, to have it flexible. You know, the team is like a living mechanism. If one body part doesn't work, the whole body doesn't work. So there should be a balance. Everyone should be at their own place, and to maintain good atmosphere at the team. If there is a good atmosphere at the team, this team will work well all the time. As Steve Jobs said, in order to do the huge work, you need to be in love with your work. If employees are in love with their work, they will overcome all obstacles that could be on their path.
Consider yourself more of a manager who prefers meetings as one of the main tools of communicating with the team, or individual approach, which is always very time consuming. So what is your preference?
Again, here you need to give preferences depending on the problems. Somewhere I watched other interviews with other candidates when they said that you don't need to come to the work. The whole work of a discipline inspector could be done remotely from home. I think that it's incorrect. No one should, everyone should come to the workplace, should do their job, communicate with other discipline inspectors, maybe, get some advices from the head, get some advice from other colleagues, without going into details. But, every discipline inspector should work like this. The discipline inspectors will get cases from different types of different categories in the system, from criminal legislation, from commercial legislation. For example, if you know that there is your colleague who is specialist on the criminal proceedings, without going into details and naming the judge's subject of complaint, you can get advice, you can have this discussion. You can't have this discussion at synergy or working from home.
Short question about the external communication. In your opinion, is the external communication, I mean with society, civil society organizations, people who want to know more about the service, stakeholders, I mean public institutions, constitutional partners, do you consider this an important aspect of the work of this service, or it is more of a capacity of the High Council of Justice and the Secretariat of the High Council of Justice regarding disciplinary liability of judges?
A good question. I think the following: as the service of discipline inspectors is going to commence its functioning from the, from the empty blank paper, from the beginning, from the scratch, they should be transparent to everyone. There are different stakeholders such as attorneys, CSOs, professional complainants. All of them, they are going to submit their inquiries, their complaints, their informational requests, maybe some kind of informational pressure is going to be carried out. That's why on the slides I have shown and I have indicated there should be operational support service to the head. There should be one or two employees who are going together with the head, provide answers to those inquiries and questions. There should be a designated employee who will administer the website. Maybe it will not be the website specifically for the SDI. Maybe it will be a separate section on the HTJ website. But to be concise on some high-profile cases, what is required in terms of the public to provide information, what is the stage of consideration, whether it's considered or not, whether it was transferred. So should be objectively done, transparently done, and in any case, it should be done by the SDI rather than by the HTJ. The HTJ should provide information on their own cases, but the SDI should handle it by themselves.
Switch shortly to English again. And could you please answer now in English? Who would be the main speaking person at the service? You have already mentioned that you should have a communication expert or press secretary. So who would be the main speaking person and why? Please comment.
Must be a head of service disciplinary inspector. He must answer all hard questions to people who would ask the and in his job he must to use all principles, principle of rule of law, principle of justice, and he must be a face of a service. Thank you.
So the most important questions and, as you say, hard questions, so the most difficult or
Yes.
hot topics should be
Yes.
responded by the head, and then others could be covered by the press secretary. Did you mean this?
Yes, yes, yes.
Thank you. I would give the floor to my colleagues. Thank you.
Добрый день.
Hello.
You are currently acting chief of staff, is that correct?
Так.
For how long have you been acting?
В липні
My head was appointed for the position of a judge in the July, and since that time I have been fulfilling the functions of the acting head for 4 months. 4 months till now.
Have you applied for that permanent position as the chief?
I have not applied because in order to apply for that position, the head of the president of the court should apply, should submit my application, and the head of the apparatus should approve it. But this position is vacant right now. Maybe later, and. For me, as for any other employee or external candidate, this position is open, and everything depends on how I will succeed in this competition, maybe, and what will be the opinion in future, both of the leadership of the court and the court administration. There was one case when a person wanted to become the head of the apparatus, but they observed how it works and they just refused to have this position.
PowerPoint presentation and your discussion, you talked about the 5,000 pending complaints. Do you know where you got that number from?
я дивився.
I followed the statistics of the consideration of complaints by the HTJ and how many they have considered from the very beginning when they started to fulfill those duties and authorities of discipline inspectors. That was during 1 year. So I did my math, I just calculated it, and roughly this figure 5,000, that's what I got.
Це оптимістично.
That's an optimistic figure.
In your motivation letter, you reference 13,000 complaints.
Я був впевнений,
I was sure that from motivation letter, when it was drafted in June, and actually 8,000 have been considered since that time.
As my colleague said, that's extraordinarily optimistic. So you've described your role, obviously, as the head, as the manager, but you also expect that you'll be doing some hands-on investigation of complaints.
я б хотів,
I would like, yes, I would.
How familiar do you think you are with judicial ethics? We will replace it. Okay? Okay, dobre. How familiar would you say you are with judicial ethics?
I think that I'm familiar. I think that both judges and discipline inspectors or the head, all of them always should follow both Bangalore principles and principles of judicial ethics at their work, and they should be the bright example of behavior.
When you say Bangalore principles and judicial ethics, what is the source or what is the guidelines from judicial ethics? What are you looking at to determine if there's been a disciplinary violation or not?
As far as I understand, you're asking here in terms of the part of the clause 3, part 1 of the Article 106 of the law of Ukraine on the judiciary and status of judges, regarding the behavior of judges, which undermines independence of the judiciary, and also non-decent behavior of judges, actions of whom are aimed at non-possibility to be a judge. So their behavior is non-acceptable and blatant.
You cited the legislation. Any other sources that you can refer to?
Так, я процитував, бо іменно частина пункт 3
Yes, I cited because specifically the clause 3rd, part 1 of the Article 106, that's the key one, which we need to pay attention in terms of the Bangalore principles and the code of judicial ethics, specifically the disciplinary responsibility in terms of this part of this article is the heaviest one. Yeah, so that's one of the heaviest liabilities. It could lead even to the dismissal of a judge. Specifically, compliance with Bangalore principles and the code of judicial ethics for each judge and discipline inspector should be at their utmost priority.
Of the Bangalore principles, which do you think are the most important?
Я вважаю,
I think, first of all, that's access to justice. Second, transparency and openness of the judicial process and the court process. And also, what I think is the most important principle, both for judges and discipline inspectors, that's proportionality. For each action, there should be a relevant liability or punishment for a person.
And I think my last question is, you said that you have a lot of people that you supervise, 100 plus. And you said you've never had conflicts among these employees? I mean, employees are always, they always have problems with each other, whether it's somebody who is too loud, or someone shows up late, or someone doesn't meet a deadline, or somebody talks too much. Have you had any of those situations where there's conflicts among employees?
Just to clarify, conflicts between employees or between me and employees?
Conflicts between employees.
Look, of course, at such a huge team, maybe such small conflicts could happen every day, but usually they could be mitigated just on the lower level. It doesn't go up to my level, so I get only information about results. That there was such station, it happened like this, it was resolved, and so on. But speaking about such difficult conflicts, comprehensive ones, which required intervention from the head of the operators, the deputy head of the operators, it's a rare case. Usually everything is solved on the lower level by both parties to the conflict, so to say. If there were some cases that indeed, people don't like each other, and that's all. We just divide them into different teams, and that's all, and problem disappears.
Can you describe a situation where that's come up to you, where it's been a serious conflict between employees?
Yes, I can describe. For example, many years ago, we had one employee who was not working. He was removing himself from the performance of duties. How was it manifested? The head of the department was telling many times that the employee was sick all the time. Like, the person can't be sick all the time. I realized that. It came to the situation when we started checking her sick leaves. We started sending them to the Ministry of Health, and they sent us responses that yes, really, this sick leave was open, that was a genuine document, that was not a fake document. Later on, we started finding out the problem. And every time, the employee could be sick for 9 months, for example. Sick for a month, 2 days on work, then again sick for a month. And all the time, there were different sicknesses and diseases. Not the same doctor or the same problem with the same body organ, like heart, liver, kidneys, every time something different. Then we realized that the employee had slightly different problems. Maybe there were some psychosomatic or neurological problems, and the employee resigned. For this employee not to show how you can remove yourself from performance of your duties to other employees. Like, we reached an agreement that this employee should stay at home and get better.
Good afternoon.
Доброго
Good afternoon.
With my question regarding your PhD thesis, the theme was theoretical, legal and procedural aspects of participation of an interpreter in criminal proceedings.
Так точно.
Why did you pick this subject?
Я обрав
I picked this topic of the criminal process because when I was studying in the university, probably for each man in university in Lviv, in my Lviv university, I, as every man, probably I was mostly interested in the criminal law, in the criminal proceedings, criminalistics, forensics. I never thought back in the university that I would work in the administrative court. Back then, I believed that it was boring work, but the criminal law was so exciting for me. That was like more manly. And basically, it was interesting for me. Besides, in 2012, the CPC was amended, and The interpreter, according to this new criminal procedure court, was one of the key parties of the criminal process. And basically, my dissertation was one of the first papers in independent Ukraine, which distinguished rights, salary, duties of the interpreter, who was receiving all of that during fulfillment of duties.
My second question is conceptual and abstract, and I'm interested to see how you will think about the question. You can walk me through your thinking. We have the concept of judicial ethics and integrity of a judge. And I would like to know, what do you think? Is integrity part of the ethics package, or the other way around? Is ethics part of integrity package? What is your opinion?
Я вважаю,
I believe, and I think that for sure, judicial ethics is included into a more broader concept of integrity. Integrity can cover judicial ethics as well as lifestyle, means of communication with colleagues, style of communication, legality, rule of law. Integrity is much broader, and it also includes judicial ethics.
But the Bangalore principles list integrity as one of ethics principles. What to do with this?
In our legislation, judicial ethics has a boundary with integrity. It's like overlaps with integrity. Once judges are checked for integrity and they fail to comply that, then they lack integrity and judicial ethics. If we look at Bangalore principles, I think that in fact they should be like overlapping. Objectively speaking, integrity is broader than judicial ethics. It should include judicial ethics. If the person has integrity, it's not enough to say that the person is just ethical. And if we say that the person has integrity, then you have to be both ethical, you have to be diligent, and to have all the other qualities, good qualities, in order to be able to call it that you have integrity. You have to be broader.
So my third question is this. Have there been any situation when you found yourself on a crossroad? For example, your integrity might be challenged. You could go one way, which would be easier, but would compromise your integrity principles, or you would choose another route, which would be much more difficult, and it would be costly, and it would have consequences. Have you ever faced such situation in your professional life? We can also simplify this question. Have you ever had an ethical dilemma?
дякую, що спростили.
Thank you for simplifying the question. You know, I've been telling a lot about the court that where I work, about the situation that we have. Maybe that's not me crossing every day over my ethical visions, but there are some things that I don't like in what I'm doing. For example, until now we have a large number of unregistered cases, motions, many new incoming documents. And now, as the acting chief of staff, every week I need to adopt instructions with which I oblige employees to work every Saturday. And previously, in the past, I used to work with them together on every Saturday. But my son was born, and not always I managed to come to work and not every weekend I can dedicate my attention both to work and family. So that's it.
I think it's all.
We can switch to the last part of the session. Yes?
Колеги. Colleagues. The candidate the candidate provided answers to some questions which we asked with respect to source of origin of funds used to by him and his family members to purchase real estate and movable property. In fact, the answers have been provided. The candidate has provided them. I would like to point out that most of the property that you have is thanks to entrepreneurial activities of your parents. All the questions were mostly about the property owned by them. Yes, yes. And with respect to the asked questions and received answers, I have no additional follow-up questions that would require any clarification. With respect to the question that's about the financial integrity, with respect to your internship, now we are moving up to the ethics norm. With respect to your internship with the attorney, you informed that you had this intention, but then you find out this incompatibility of two oaths that according to the legislation it was not compatible to have two oaths at the same time, so we've clarified that. The question about your dissertation. I will ask this question. Since the academic supervisor was the father of the court president. Yes. Coincidence, not coincidence, it happened like that. I can explain. Yes, please. I graduated from Ivan Franko Lviv University, and I was looking for the possibility to defend my candidate's dissertation. I did not have a chance to study at the postgraduate program because I could not combine studies with work. I had to be assigned to some university with vacant spots. Back then I was visiting Lviv, I came to the faculty, I asked whether they had any vacant spots, whether they had this chance, and they had informed me that all of their vacant spots were taken, and he suggested me you can go to Ternopil because Ternopil region is close to Lviv region. He gave me phone numbers in the reception of heads of these universities. I called those universities and asked whether they had any possibility to be assigned to their university in order to have this possibility to write my dissertation there. I called Ivano-Frankivsk and yes, they said yes, we have. Then I started finding out more about the university and I saw that the surname was identical. Back then I already worked for several years in the court. I approached the court president and asked, is this your relative? And he said, yes, that's my father. Then I came there, I submitted my application, please assign me to the university. I was assigned to this university. Then there was adoption of the title of the paper. I passed through all the procedures, and that's it. It was just coincidence. Okay, the story is clear. Once you defended your dissertation, do you have any academic papers? Have you published anything since then? I've published a lot of articles before that. After defense, actually, my views with respect to the criminal process switched to administrative process. So you've lost interest in the criminal process. The matter is that over 10 years since I defended my dissertation, it hasn't brought me nothing. I have not received any additional payments. I did not teach in the university. Maybe I wanted to teach a bit at part-time, but given the workload in my court never allowed me to combine that with teaching. And then family, COVID, war. So, okay, no time for academic papers. I have no more questions.
then we can come to the very last part of our interview. And now you have 2 minutes for your final comments. We've exceeded our time.
Дякую
quite
вам.
significantly.
Дякую вам.
Thank you. Thank you, all members of the selection commission. I would like to say that actually you have made huge work during this competition. For the first time, I faced the situation that after the practical assignment, many papers were published at once at the official website. Not in other competitions, like in course, in prosecutor's office, I've never saw that. Probably you are the first commission and the first competition which published all of that at once. I would like to express my gratitude to you for this work. I would like to wish you success in your future endeavors and good health.
Our decision will be announced on Wednesday. Thank you for coming, for sharing your insights, and good luck. Thank you.
Дякую вам.
Thank you. See you. Goodbye.